guys, I'm a little confused, which, as you know, is not hard to confuse me. Um, in the chat on crime, it said that Karen and Turtle Boy were in another courtroom because there's some kind of motion to dump their phones. I didn't hear anything about that. I thought, oh, I guess that's Turtle Boy's case. I was about to say I thought that had been taken care of, the phone situation. But apparently that's in Turtle Boy's case, I guess. I don't know. And so they were saying it wouldn't start on time. So I was sitting here waiting and I was going to get something for us to watch in the meantime. And then it started, but it started in the middle of Brennan's sentence. So we're just gonna have to go with whatever we missed. But it just started, so we didn't miss too much. But that is weird. So I'm assuming she's back in the courtroom. Back in her courtroom for her.
To pursue or obtain other information available in a separate case. First, Karen Reed and Judge Cosgrove, Special Prosecutor Cosgrove, because from the beginning have a very
okay, that is not StreamYard. That is Court TV. And Law and Crime had similar technical issues earlier, which is why I chose to use Court TV's feed today. They completely lost signal and had to start their feed over. So, is somebody sabotaging the live feeds from the courtroom?
information that's been publicly available, and that's why my motion cites a search warrant, an affidavit and a search warrant, and there are two pleadings as well in my motion that are on the public docket. And so what I know is that there are two phones that were searched by relevant material to Karen Reed's case. The reason why it's important and relevant is that
oh, good Lord.
to Carney, but relationship and where information, some of the suggestive grand jury minutes, was passed per Carney. Originally, a third party was used, an intermediary, where
we gotta find a different feed.
I don't know that. I know that the attorneys are very well aware.
Let me ask you, so Tully's affidavit either in the substantially itself or in the addendum A?
I would re-review, but it very well may.
Well, that's a critical issue here with regard to the purported relevance of the data sought. Let me ask you this, Attorney Brennan. Has the extraction reports been generated?
I understand they are available to special process and they have generated.
Has the underlying data from the two phones in question been assembled?
I understand that personally
The vote, okay. As it relates to conscious,
Yeah, I think this is the hearing with yeah, you're right, Judy. I can't I'm frazzled right now. I'm sorry. I'm trying to find yes, StreamYard did crash, but court feed court I can't talk today. Court TV's feed was glitching. So we're gonna try on crime. Oh, yes, that is much better. But we're gonna start over. Yes, so this is the hearing about Aiden and Karen because they think they're colluding to, I guess, intimidate witnesses or something. I like using Court TV better because they're nicer to streamers than Law and Crime is. But you gotta do what you gotta do. But Law and Crime was having problems earlier. Their whole stream like disconnected and they had to redo everything.
Commonwealth lawyer is obligated. Case law that specifically says under these circumstances, a Commonwealth lawyer is obligated to obtain a Rule 17 subpoena to pursue or obtain other, but these are a bit unique in circumstances in that I am a specially appointed prosecutor to Karen Reed's case, Commonwealth versus Karen Reed. And
Specially
Judge
appointed
Cosgrove, Special
dumbass.
Prosecutor Cosgrove is specially appointed to Mr. Carney's case. Because of that, I have from the beginning kept a very strong line of separation between both Mr. Carney's case and Ms. Reed's case. I have only sought information that's been publicly available, and that's why my motion cites a search warrant, an affidavit in the search warrant, and there are two pleadings as well in my motion that are on the public docket. And so what I learned is from my public reading and from watching hearings. And so what I know is that there are two phones that were searched by Trooper Tully and is in the possession of the Norfolk County District Attorney's Office, and the information is relevant material to Karen Reed's case. The reason why it's important and relevant is that separately, I possess information that establishes not only a relationship between Karen Reed and Mr. Carney, but a relationship in where information, some of it private, some of it suggestive grand jury minutes, was passed purposefully from Karen Reed to Mr. Carney. Originally, a third party was used, an intermediary, where allegedly Ms. Reed would send the information to the third party, would then be sent to
Counsel, let me stop you there. Has the name of the intermediary appeared in the public record?
I don't know that. I know that the attorneys are very well aware of that person's name. It may be, but I don't know that, and that's why I
Let me ask you this, counsel. Does the name of the intermediary appear either in the substance? Let's say with regard to the purported relevance of the data sought. Let me ask you this, Attorney Brennan. Have the extraction reports that have been requested been generated?
I understand they are available to prosecutor. They have
The underlying data from the two.
I understand that it has. I cannot personally confirm because I have not asked to review it personally.
Do you know the
Damn. Don't crash when I'm having fun. StreamYard. No, that judge is for Turtle Boy's case. Unfortunately, I think that must be Turtle Boy's judge. Because he wants Aiden's phone for the Karen Reed case. No. Unfortunately. I wish. I want that judge. Can we kidnap Bev so that judge has to be on the Karen Reed case?
Trying to prove a case of intimidation of a witness beyond a reasonable doubt. What we expect evidence will show separately, in which Ms. Reed would provide information indirectly to Mr. Carney. That information would then be reviewed by Mr. Carney, posted on social media, and consequently was used, we believe, allegedly, to intimidate and harass witnesses. In the search warrant on how Mr. Carney targeted witnesses, the express that this trial of Ms. Reed never go forward.
Okay, StreamYard, I'm going to have to turn my camera off. Brennan, watch him. He is so rattled right now. He is so confused. He does not know what is happening because he is so used to getting his way that he is totally confused. This is hilarious. So, Turtle Boy is a journalist. He's a YouTube journalist, but a journalist nonetheless. And he has investigated this case and believes that Karen Reed is innocent, like many people do. And apparently, he has been. Hey, Maiko. Apparently, he has been in contact with Karen Reed. And I don't think there's anything wrong with that. But he doesn't back down when if he is somewhere and those witnesses are there, he'll go right up and talk to them and doesn't back down. And that's what they're calling witness intimidation. And I don't like his style. I don't like that he just happens to show up places where he knows they're going to be. I don't like that. I think he should keep to himself, especially now that he's got everybody all riled up.
Text messages, pictures or videos from April 1st, 2023 through and including October 5th, 2023, 7 months of material that ostensibly could include meeting notes, calendar invites, text, videos between Mr. Kearney and the defense. So those are relevant.
First, this is a ruling with Mr. Kearney, so I'm asking that Mr. Kearney his attorney be at the table. I'm not sure why we're being joined by Ms. Reed's team, unless they have standing in this.
We're a little bit, I don't mean to interrupt, but as we didn't see which case number was called. Reed's case number, Judge Canoni's number. I specifically asked that question at sidebar day before yesterday, and she said yes. The Rule 17 Mr. Brennan's dealing with is on Ms. Reed's case number as it pertains to her rights and the
This
issue.
meeting is being
Counsel.
recorded.
Counsel, it has been called in this case, but I don't know that your client has standing with regard to this particular issue.
So the case number, I just want to make sure procedurally
Stop
counsel
buffering and turn
and
my
we have
camera off.
we believe we have a right to be heard on this issue because it does attend to her rights going forward in terms of, I mean, this
Request related to documents produced in another case.
because it specifically to the prosecutor asking for information in her court, her consciousness of guilt, et cetera.
Your evidentiary issue, which you dealt with at a later time. Those, what you're, all of it before the court is a Lamprin hearing on material sought from Mr. Kearney's case. The evidentiary issue will be dealt with at a later time.
And respectfully, I don't necessarily disagree that from an evidentiary standpoint, ability standpoint, that can be dealt with. The case should never be called without my client. She has a constitutional right to be here and to be heard, even on Rule 17. Over and over information, messages or whatever. I'm only asking that we be entitled to be heard on this issue, even though it deals with Mr. Carney's phone and he's got legal representation. It also attends to Ms. Reed's rights, and it's her case number. And the reason the Commonwealth is trying to bring it in is to deal with her, it's not Mr. Carney's case. So she has to have a right to be heard.
Captain's been pending for a week and a half. I don't have any submit for that.
We did to Justice Canoni
Okay.
day before yesterday.
And what do you propose, counsel?
The only thing I propose, I don't want to interrupt Mr. Brennan's argument, but when this is finished, Ms. Little is prepared to address the court on the very issues that he's bringing up.
I'll take consideration. Is there any issue such that that causes any issue for any of the parties?
No, absolutely not, Your Honor. Again, I will step back. I will get a little mouse in the room. I just need to be in the courtroom. And once Brennan is finished, before the court makes the ultimate, and once Mr. Radel is finished, I think we should be provided an opportunity to be heard.
I'll consider the request.
Okay.
No objection procedurally. Wants to join in my file. That's an issue.
Thank you. Thank you,
Well,
Attorney.
Your Honor, I do object. Ms. Reed's counsel, Ms. Reed do not have standing for this motion, able for this motion. It's a rule set. Privacy interest in these materials. She has no standing to object. And she's not a party on the rule 17.
Thank you.
Yes.
Brennan. She is a party in this case, and I'll allow her to have resident, and I'll consider concerning the substance of the motion and her
Thank you, Your Honor.
considerations there
We
too.
appreciate the court accommodating.
So ADA Brennan, apologies for the interruption. To show that the requested materials are relevant, involves the breadth of what has been requested. And perhaps you could speak to that and how materials that
I understand the court's concern, and I've looked at addendum A as well. And I've identified the information I think is relevant to the Rule 17 subpoena. So I agree the Rule 17 subpoena speaks broadly, but what is relevant is sections D, E, and F. Now, mindful that there was probable cause to witnesses in the Commonwealth versus Karen Reed case. E is pictures or video depicting evidence of intimidation of a witness. So similarly to D. And so D, E, and F are squarely on point and relevant to the Commonwealth versus Reed case.
You talking about Turtle Boy? Because Brennan wants Turtle Boy's phone for the Karen Reed trial. Because he wants to prove that Karen is the one that was actually intimidating the witnesses through Turtle Boy, and that proves consciousness of guilt, which means she did it on purpose.
Filed in this case, not Karen Reed case, Mr. Carney's case. One is the Commonwealth's opposition to defendant's motion to suppress and to restrain any searching of a communications device. He also notes in the motion that there does not appear to be any attorney-client privilege materials. There is a second source as well, and that is in the Commonwealth versus Kearney case, docket number 53, Commonwealth revised proposal for examination of digital material seized. That's relative to the 4 phones that I'm not seeking. However, it's instructive because in that motion as well, it talks of client privilege communications in the 2 phones that I seek. And so, given the separate evidence that we invite, she was recently on an air broadcast on a documentary last night, the night before, and the night before. There are admissions that she was, in fact, providing information to Mr. Kearney. Reflects upon the consequence of Mr. Kearney's actions, which she helped fuel by providing this information and identifying the witnesses in her case. I do have a clip, if the court is interested, because it gives great depth and this court. And so in light of the fact this information was used to warrant prohibitions of the sharing, inevitably the obvious consequence of witnesses, this is relevant. The evidentiary basis is clear. I do not have access to this material if a Rule 17 is necessary. And again, I filed the Rule 17 out of an abundance of caution to be beyond reproach. If it is not necessary, I will simply go and obtain the information on my own, but I think it's more prudent to have a court order. It's necessary before trial. I'd like to review the materials that are relevant, and I agree the scope should be limited to D, E, and F, not the entire phone. And those materials would be provided to Judge Cannoni in a motion in limine regarding conscience of guilt. Also, will dictate what at trial, which its notice is important for both and the defense. It's in good faith. I provided both pleadings from Mr. Kearney's case, the search warrant, affidavit in support of the search warrant. I've offered videos of the admissions by Ms. Reed to the relationship. And so for those reasons, I ask you.
Dang it.
Counsel.
Thank you very much, Your Honor. Good morning, Your Honor, counsel.
Morning.
Judge, this is a Lampron request, is the case, and I know you're familiar with it, Your Honor. The purpose of the court's focus is on preventing unwarranted harassment of witnesses and third parties. The focus was done back, I believe, in February of 2024. So here we are at the 11th hour, and the Commonwealth is throwing, last minute bombs. It's amazing to me how many motions in limine are filed. The government's trying to try that case of a trial. It was my impression of that. So, we're not getting to these 11 and in on. As you said, not potential relevance, but actual relevance, not otherwise obtainable at trial. You can't prepare for trial without it. And most important, judges, that the application is made in good faith and not as a general fishing expedition. This is the ultimate fishing expedition, Your Honor. And I want to go back. When this happened, Judge, we didn't have a dog in the fight back then. As far as my client and I knew, they were going after Ms. Reed for communications with my client on this witness intimidation issue. Well, counsel wants to tell you that, oh, well, there was probable cause in a search warrant, but then they took it to a grand jury, so we're past that. They had the two easiest forums you can have for a prosecutor. Sitting in the judge's lobby, shooting the breeze with a search warrant affidavit in front of you and nobody else there. And then they went to the lowest hanging fruit.
You, not me. When you say you, not me.
Right, not you, Your Honor. And then they had the lowest hanging fruit you can get as a prosecutor, going to a grand jury without anybody else there, crafting the evidence in any sort of way they wanted to. And thankfully, and it doesn't happen very often anymore, but the grand jury said no. The grand jury said that there is not probable cause. Again, the lowest hanging fruit in our system. They couldn't establish probable cause based on this information. And I remembered when this happened, just sort of not even so much representing Mr. Carney, but just as a constitutionalist, as a person interested in the Constitution, as an attorney, I saw this. I read the search warrant, out of the Herald or something, and I was prompted to write this press release that I sent out about this exact issue. And I went back to it. I looked at it again this morning, and it really covers exactly what's going on here. And in that search warrant, Your Honor, it's very clear that the government just wrote a 30-page short story about its efforts to try to find and isolate, and you have it in there, right, to find and isolate communications. And the government wants to criminalize communications. And if you look at my press release, and I'll submit it, or I'm just going to read a few things from it. We have in this Commonwealth a very special provision in our own Constitution that Ms. Reed has the right to present all proofs. And she has the right to fight any way she wants and talk to anyone she wants and communicate with anyone she wants and say, hey, don't share this. Hey, keep this between us. That's her right, her constitutional right under the Massachusetts Declaration of Rights to present all proofs. So when the government cites that just as a bare proposition, she tried to keep this secret. She communicated with Aiden Carney. Then we're going to make this gargantuan leap that she's sharing the intent to intimidate witnesses. So the whole thing is completely bereft of any evidentiary value, Your Honor. Just the notions that they put in the search warrant, and ultimately the fact that they tried to use it to get an indictment and failed. So that's why this has no evidentiary value. The relevancy is zero because they can't put it into evidence. And then further, Judge, as a practical matter, I looked at the docket. I spoke with counsel. Agreed nothing in their case in chief relative to this issue about getting with Mr. Carney and conscious. The door sort of proposition that ain't never going to happen in this case, Your Honor. And so that adds to the issue of whether this is evidentiary or not. The government's already backed off. The government got a search warrant filled with nothing but investigative pronouncements. We took a trip to California. We talked to this lady, and they were communicating. All they say is they were communicating. They don't say, hey, let's really get that person and let's get them off of this and let's try to have that person not testify, scare that person, let's harass that person. There's no communications like that. They just have the communications. That's not right. So here, we're about interpretation of the witness intimidation statute graft onto any communications in our client's phone, in my client's phone, Your Honor. So There's a few more complicated things, Judge. I feel like you have it, but I just want the court to be aware, having come into this case at this point, there's a pending motion to dismiss with Judge Doolin, basically saying that all these witness interrogations don't cut it for the Constitution under the First Amendment. So that's number one. Judge, it's a team issue. Counsel's doesn't right. So the taint team covers everything, all of Mr. Carney's phones. So and forged ahead, the taint team could get set up, should not inure to the benefit of, and this is a firewall type of a case with respect to a special prosecutor on the one side and the Norfolk County DA's office on the other side. A Rule 17 motion is absolutely required here, Your Honor. That's the whole point of keeping this confidential and separate. So the Rule 17 territory is entirely appropriate, Your Honor. In terms of...
Counsel, what's the legal import of the pending motion to dismiss in Mr. Kearney's case?
Sure.
How does that change either the relevancy analysis or the evidentiary value analysis in this case that I must make in the Rule 17 context?
Sure. So we expect Judge Doolin to come back with a decision that says all of these communications, maybe they're distasteful, maybe they're obnoxious, maybe we don't like them, they're all protected by the First Amendment. So let's look at the search warrant. They're looking for communications between Ms. Reed and Mr. Carney. They don't even have that much. They don't have quotes. They don't have communications. They just have the idea that, well, they communicated. The fact that they communicated cannot be a basis for a criminal investigation in the extraordinary step of getting into the phones. A couple of quotes on the cell phones, Judge, just to set the context. This is what from Commonwealth versus Onyx White. That is a landmark case that involves the notion, and you know, the government is always pushing the envelope, Your Honor. That case was very dangerous. The government was trying to set up a state of the law where just because we all have cell phones in our back pocket, in almost every case, let's see in that cell phone whether they communicated about a crime. And it would have been an unbelievable expansion of government power to search people's private information.
Hey, Rob.
Thankfully, the SJC said, no, you need to have a nexus between the phone and the crime. And they cited some other cases in terms of quotes about cell phones. Just two quick quotes, Your Honor. The cell phone is a repository of just about everything that is materially important to a possessor. Documents, messages, emails, notes, thoughts, communications, photos, loved ones, information involving loved ones. The court should not view lightly what the Commonwealth is seeking here. Cell searches would typically expose to the government far more than the most exhaustive search of a home. So
I appreciate that, counsel, but at the same time, the phone has been searched. The data has been obtained by the Norfolk District Attorney's Office. It's in it's in Special 88 Cosgrove's possession, custody, control. It's already been seized. 88 Brennan is looking now, it seems, for a very narrow subset of that information that does not contain the long list of materials that you just rattled off from the Onyx White case.
But it never should have happened. The search never should have happened.
That issue isn't before me, counsel. That issue isn't before me. The issue before me is what he's looking for relevant.
Right. What do they have? What do they have to set that up? They have the fact that they spoke, and the fact that they spoke is not evidentiary. It's not relevant. If the fact that they spoke was the basis, we'd be at Onyx White. We'd have the wrong decision in Onyx White, Your Honor. That just because people speak, the government gets to ferret around in their phones. It's a horrifying concept, Your Honor. That's really the crux of why I'm here. And the last thing I'll say, Judge, is that the fact that they got around the taint team we shouldn't just forget about the taint team. These phones need to go back through the taint team if they want to look at them. And On the taint team issue, there's more litigation to be done where they already allow scrutiny of the phones by a taint team for attorney-client privilege information. And my client at the time had many civil and other cases going on at the time. So Attorney Cosgrove's statement, there's no attorney-client privileged information in the phone is ridiculous. There's a ton of it. We're also asking right now, Your Honor, for the taint team to scrutinize the phones for, we're going to ask for husband-wife
Counsel,
communication.
you're not asking.
No, not you, just so you know what's out there. I just want you to know what's out there.
I understand.
We're asking for husband-wife communications. We're asking for that journalist source materials, of which there's a plethora. We're asking that those be scrutinized by the taint team and all that stuff be taken out. So the taint team issues are still in flux. You know, the fact that they did this, the court should deny this, Judge, just on the fact that this is an 11th hour request. If you look at Lampron, it talks all about undue delay. They had this February of 24. Here we are now on the eve of trial on their case. So for all these reasons, Judge, we object. This is a gross invasion of privacy. It's a fishing expedition. There is no hook that they have to say, we will find something criminal in those phones. Thank you, Your Honor.
Thank you, counsel. So, ADA, Brett, before I hear from you any further in response, I am going to hear from counsel for.
Okay, a taint team is someone that I can't think of the word. Reviews the information on the phone and makes sure that things that are supposed to remain confidential remain confidential. So they're a uninvolved third party. So any confidential communication between the person and their lawyers doesn't get put in with the other information. If they are a journalist and they have sources on there or big news about cases that they're covering that's not involved in the case that they're in court for, those things don't get released. Anything on there that's confidential or work product or with a attorney or anything like that that is protected, the taint team makes sure that that doesn't get released to whatever case it's being subpoenaed for, because that has to be protected. It's protected under the law, and if that gets released, it can do a lot of things. It can cause a mistrial. It can cause a lot of bad things to happen. So the taint team is an uninterested third party. I think it's usually a lawyer, but it doesn't have to be, I don't think. And they look at that to make sure that everything goes smoothly and the stuff that's supposed to be subpoenaed and put in the trial is, and the stuff that's not allowed to is kept out.
The defendant in this case.
Yeah, pretty much.
It's going to be Attorney Elizabeth Logan, Your Honor.
Thank you, Your Honor. Elizabeth Lillo here on behalf of Ms. Reed. First, I just wanted to thank Your Honor for allowing us to be present and to be heard on this issue. The defense joins in Mr. Bradle's request in opposition to this Rule 17 motion. There's just two very brief points that I wanted to address that I don't believe were addressed by Attorney Cosgrove. Your Honor, if you take a look, Attorney Bradle, apologies, Your Honor.
It's a lot of
There are. Your Honor, the Commonwealth's affidavit in support of the Rule 17 is facially deficient as to both elements 3 and 4 of Lampron. The Commonwealth does not include a single fact in the affidavit to show that it cannot properly prepare for trial without the production of this evidence. So just on that basis alone, the rule is deficient. That's same with regard to element 4. If the court looks closely at the affidavit that was filed in support of the Rule 17 motion, the Commonwealth is required to show that this is not a fishing expedition. The Commonwealth, again, does not set forth a single fact or even a conclusory allegation as to element 4. And that's because the Commonwealth knows full well that the grand jury has already rejected the Commonwealth's claims that Ms. Reed was somehow engaged in witness intimidation with Mr. Kearney. And on that basis, because it's facially deficient, this has to be denied. We therefore respectfully request that the court deny this Rule 17 motion.
Thank you, counsel. ADA Brennan, I'll hear from you in response briefly.
I think most importantly, the parties are conflating two issues. Whether there is probable cause beyond a reasonable doubt to convict a person of intimidation of witness in the relevant conscious of litigation in Mr. Kearney's case. But these phones are in possession of the district attorney's office. The information is available. It's been represented as a privilege. There is nothing to slow down or stop the availability of the information. It is relevant for the judge in Commonwealth v. Reed to assess whether or not this information establishes consciousness of guilt. That is the issue, not the complaints or the concerns or the personal opinions, the constitutional prowess of Mr. Brado. It is this reflective of consciousness of guilt? And
Hey, Brennan, on that issue, on the consciousness of guilt issue, there was some suggestion, there was an agreement that the Commonwealth was not intending to introduction of evidence concerning that issue unless.
that is not entirely accurate. There was a motion filed by the defense, and they were concerned that when they were cross-examining witnesses in the case, that at the past trial that I was at, the witnesses then offered to the jury that they were being harassed by social media bloggers, suggesting at the behest of Ms. Reed. That is an entirely separate issue than consciousness of guilt. I agreed that unless the door is opened, a witness should not get up and talk about their state of mind and how they believe they were harassed. I agreed to that because I will instruct the witnesses unless the door is open and you have an invitation, that would be improper. Separately, a consciousness of guilt motion in limine, which I expect to file
Wouldn't open last
if
time.
it's vital information, is an entirely different proposition than opening to the state of mind. Consciousness of guilt has more to do with the conduct. She do her consciousness of guilt to try to cover for the crimes that she's alleged to have committed. We know she was providing information, even protected information to Mr. Kearney. We know he was publicizing it, appearing at witnesses' homes and addresses. We know the conviction on addition of witness are not very intimidating. We know the mental anguish they suffer. The defendant in our case, Ms. Reed, well, because if you do see the video, with a smile, she acknowledges the consequence of her actions and seems to encourage. And so this evidence should be available to me. I should be able to assess it. I should be able to provide a motion to eliminate to Judge Cannoni if appropriate, and then she should decide the admissibility in the Commonwealth v. Karen Reed trial. Thank you.
Thank you, counsel. Folks, I believe I've heard all I need to hear. I will take this matter under advisement. I appreciate your filings and your oral advocacy today, and endeavor to get your response as soon as possible. Thank you.
Thank you.
It's dinner. Yes, exactly. Right. Exactly. So if you want to, reupholstering is really expensive,
Yes,
right?
it is.
If you,
What was that?
StreamYard, quit telling me I'm on Wi-Fi. I'm not. I am connected with it. I just want to say I love Attorney Little. She looks like this little girl with this little shaky voice, but she's so smart and she makes such good points. Like, you don't expect that when she gets up there. When she gets I started to say older. She's a kid to me. But when she gets more experience and gets a lot, more trials under her belt. So, is that the same courtroom or is that a different courtroom? Why can't they all just stay seated and have Bev go to that courtroom? That seems silly. A year ago, I didn't know what a tank team was. StreamYard, if I had a woodshed, I would take you out back to my woodshed and spank you. So, what they're trying to do is prove her consciousness of guilt. Because she talked to a journalist, consciousness of guilt. I don't see the connection. Unless they find an actual text that says, go intimidate this witness. That's not consciousness of guilt. And Brennan's fishing. He even admitted he has no idea what's on the phone. He didn't know anything. The judge was like, how much material do you need? How long is it? How much is it? What's on it? I don't know. I don't know. I don't know. He knows nothing, yet he comes before the judge and asks for it. I gotta get that dumbass clip. I had it. Be glad that it crashed that time, y'all, especially if you're wearing headphones. Because we got the You know the test pattern thing, the lines with the colors, and a screech. It was ear splitting. And I don't have headphones on. Right. And he's saying that because of that, that shows consciousness of guilt, that she knew that she did it. So she wanted the witnesses intimidated so she wouldn't be found guilty. Why would he need to do that? Then the grand jury indict her? That's why we're having a trial, right? I don't know. Okay, well, Bev is on the bench. I have to figure out. Oh, wait. Where are we? Okay, switch to Court TV, and they got their feed fixed. So hopefully, it will be better now. Oh. Okay. I gotcha. No, I didn't mean to do that. Don't you hate it when you go to click on a button and a different button jumps in front of you and you hit the wrong button? I hate that.
Okay.
Yeah.
All right. Thank you.
Well, the grand jury indicted her, Carla, on information, and the lead investigator just got fired for his misconduct in this case. So that could totally change the information that he gave the grand jury. Should she even be on trial based on his investigation? Should the whole case be thrown out? So now Brennan's grasping at straws because he knows it looks bad that she's even on trial at all because the lead investigator just got fired. And when did you ever watch the Lawyer You Know video that I told you to go watch? I know you were busy rewatching me, but and then you had to watch the pet parade on Biggins. I don't blame you. I had to watch it too. But he explained why this is good for the defense. He even did a little mock closing statement, and it was good. It was like he was talking to the jury, and he was like, "Are you gonna put a woman in jail whose case was investigated by this man?" I don't remember what all he said, but it was good. You need to go watch it. It was really good, right, Judy? I mean, it was amazing. If I had been on that jury and got a closing statement like Peter gave, I would have been like, nope, she didn't do it. Or I don't care if she did or not. That guy totally could have framed her, and there's no way I'm going to, like, it was good. But that grand jury indicted her on Proctor's testimony. He was the lead investigator. He was the one that told them what she did. and then he just got fired for his misconduct in the trial. So that sheds a lot of doubt on her indictment itself, let alone her trial.
We'll start with it's paper 593, paper 610.
Stop it, StreamYard.
Defendant's motion eliminate to allow evidence of lack of bias. Who's arguing that for the Commonwealth?
What? What did she just say? Hang on.
To allow evidence of lack of bias. Who's arguing that for the Commonwealth?
It's 16 minutes long. It wasn't a live stream. It was real quick. Wait. What was that? Who evidence a lack of bias?
I think that is protecting the interests of the Commonwealth and the witnesses from.
I don't have a problem with that. I still need cities.
Your Honor, can I be heard on that one issue, just briefly?
Which one issue?
What
The
happened?
witness list, okay?
Yes.
Expressed to the court, and I do think that the court should.
April 25th, I'll leave
Did
you.
I go backwards and forwards?
Jeopardy will have attached.
I mean,
She will be held
oh my
once in
God.
jeopardy.
I'm sorry, y'all. I'm discombobulated right now. I don't know why. I thought I was going backwards. Apparently, I was going forwards. Because the evidence of bias thing threw me off. I got really interested and wanted to hear it again.
Record starting with the Commonwealth.
Good morning, Your Honor. Barbara Boston for the Commonwealth.
Good morning, Mr. McLaughlin.
About for the Commonwealth. Good morning, Your
Good
Honor.
morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson from the street.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor. Robert.
Mr. Alessi.
Good morning, David Unetti for Karen Reed.
Good morning, Mr. Nettie. Good morning, Ms. Reed. So a lot covered this morning. I'm going to start with, I was just handed a couple of things to that I'm going to need some time to read. What I'd like to start with is paper 613 filed yesterday. Defendants assented to motion to continue trial date to a date on or after April 25th. Who's going to argue that? Because just because it's an assented to motion does not mean it's not likely going to happen. So I need to hear argument on why I should do this.
I'll address the court with the court's permission.
Yes.
As I indicated to the court the day before yesterday, there is an issue, a very ripe issue that is currently pending before the First Circuit. We believe very strongly that if the First Circuit were to take some action as to count 1 and count 3, just to reiterate what I've already said, but I can sort of clarify it and narrow it down. If the court were to take some action on counts 1 and 3, which is currently before the First Circuit, for instance, if it were to be remanded for either dismissal or something else, additional hearings, etc., then that puts the entire case in jeopardy. Once the jury ultimately is impaneled and thereafter sworn, jeopardy will attach. There will be, if in fact there is action taken on count 1 and count 3, we will be in a position where we will seek a mistrial. Jeopardy will have attached. She will be held once in jeopardy on count 1, 2, and 3, and we believe that puts the entire case in peril. The case that we're defending right now, very clearly, is a murder case, ultimately, along with
All three indictments, correct? You're
I understand
defending
that,
all three.
But it starts with murder. That's the sun rises and falls on a murder charge. And there's also vehicular manslaughter, and then there's the leaving the scene, count 3, and the subordinate counts beneath count 2 as well. That's a very different jury and a very different trial strategy than simply count 2, if we were to be defending count 2 or it's the subordinate charges. So I think it puts the case in jeopardy if we do not have at least some time for the First Circuit to act and determine whether or not it wishes to act on counts 1 and 3. Hence, that's why I suggested to the court the other day that it might be more prudent and less perilous for the case if we were to put this case over for at least a few weeks. We've spoken to the Commonwealth, and the Commonwealth tends to agree that that probably is the better practice. And we've asked for the court to extend the beginning of the trial to April 25th, which is about a 3.5 week continuance. And I'll submit.
All right, does the Commonwealth want to be heard on this?
Your Honor, the Commonwealth is relying on advice of appellate counsel. I don't contest any of the defense's perspective for wanting continuance. I think the Commonwealth's perspective is different, but not adverse. The concern is that this case in the federal court gets delayed for an extraordinarily long period of time, and we have an interest in this case going to trial as soon as possible. There is an expedited scheduling order, which could hopefully imply that there is going to be quick progress in the federal court, but we don't directly communicate with them or have any control. Our hope is that if there is a short continuance, it accommodates the defense's concerns. I understand the trial strategy for different charges is somewhat different. For a circuit to resolve the petition, or if they're going to allow oral argument, benchmark to do it quickly. And so really the primary motive for agreeing to the defense request is that we hope by offering a short continuance, the federal court will act more quickly and that we can have this trial in April.
Okay. Well, I'm not going to grant the motion. All right. We have jurors coming in
Judy, you were
that
right.
were summoned months ago. I called the jury commissioner yesterday and asked how long it would take to get the right numbers that we were able to get starting April 1st. At a minimum, 10 weeks. I'm not going to do that. What I will do is we'll start impaneling on April 1st. It will likely take a while. If we get a jury before April 25th, I'll rehear you on your motion. We won't swear the jury because obviously that's when jeopardy attaches, and we'll take it from there. But we will start April 1st with impanelment.
Thank you, Your Honor.
Okay. All right. So let's go to the next motion, and then we'll go back to doing them somewhat in order. Commonwealth's motion for a buffer zone. Jimmy, do you have an extra copy of what you just handed me? Because I don't know where I put it.
Can get one.
I have it here somewhere. I'll find it. So we did hear from people this morning. I know you all have, I have it. I have it, Jim.
Thank you.
I think Mr. McDermott gave you a copy of, I guess, what local merchants have requested.
We've received it.
Okay. All right. So I'll hear the Commonwealth on your buffer zone motion.
Your Honor, the Commonwealth's primary concern is the sanctity of the jury and the jury process. We are concerned based on past reports and information that noise, interruption, and other uncontrollable events can potentially impact the jury's consideration in this case. They should be free from outside influence, so it does not in any way oppress or push them in any direction, either way in this case. The courthouse is very close to the public areas where people congregate. It's been reported that during the trial, the jury would be able to hear outside noise and influences, not just honking of horns, but other types of noise that could be influential, intimidating, concerning. And so we've proposed what I think is reasonable and minimal recommendations to the court to move certain parts of the buffer zone, especially on the left side of the courthouse, where there seems to be a bit of attention, noise, and potential adverse influence of the jury.
And that's the same area that these merchants are talking about?
I've read that this morning, not being wholly familiar with the Dedham area. It seems that is one of their concerns. I think they mentioned an open market. In my memory from coming by on other cases at other times, there appears to be open markets in that area. And so if that's influencing their business, that is a separate but related concern that they have expressed to the court. And I do think that the court should be sensitive to the community's concerns. But importantly, that closeness and that amount of volume and influence on the jury, I think, can affect the sanctity of the jury. I don't think it is a strong imposition to consider the streets that have been identified in our buffer zone motion and have the buffer zone include limitations to those certain streets. And I think that will potentially help some of the outside impact and adverse influence on the jury.
All right. There's a portion of your motion that I disagree with. Do you want to be heard on it? About the court enforcing the buffer zone?
I don't believe the court has authority, nor should it be upon the court to enforce anything. I think law enforcement should enforce the laws and regulations as law enforcement sees fit. And so I don't think that burden should be imposed upon the court.
Thank you. All right. With that, does the defense object to the buffer zone?
We take that position.
Okay. All right. I'll take this under advisement. I have to figure out exactly how far this is. And I have not yet had a chance to read and consider today's email from the merchants. Okay. Okay. Yes.
From the record, that came from the Dedham Square Circle. The organization
People that
runs
have
the Dedham
shops
Farmers.
and stores and stuff around the courthouse.
Thank you. So we can talk about the witness list when we talk about impanelment, when we really have the heart of the final trial conference. But I do need at least cities and towns from these witnesses. Neither side gave them to me on the civilian witnesses. So, and there's a lot of overlap, and you'll have to fix that for any final trial conference report anyways. All right.
Your Honor, could I be heard on that one issue, just briefly?
Which one issue? The witness list, okay?
Yes, we did turn over our witness list along with the information that's required under the new rules, which includes, telephone numbers, addresses. We gave that directly to the Commonwealth. We did not file that publicly.
Okay.
We'll happily add the towns for the court. But I would note that the Commonwealth has not yet turned over that information that's required under the new rules. I believe they put a footnote on their witness list. I think, they can't shield themselves from their discovery obligations. It's mandatory under the rules. We'd ask that they comply with, the requirement that they provide us contact information for their witnesses.
So there is a footnote. I'll hear you, Mr. Brennan.
Your Honor, the motion notes that the Commonwealth moves to be partially exempt from Rule 14 because of the past history of perceived harassment and intimidation of witnesses, which the Commonwealth believes is ongoing.
No.
I think a potential resolution to this to comply with Rule 14 is that we be allowed to provide it to the attorneys under seal. I think that is protecting the interests of the Commonwealth and the witnesses from.
I don't have a problem with that. I still need cities and towns.
Of course.
Okay.
Yes.
All right. Thank you. So we will start with it's paper 593. The Commonwealth's response is paper 610. Defendant's motion eliminate to allow evidence of lack of bias. Who's arguing that for the Commonwealth?
The Commonwealth first, Your Honor.
Oh, it's defendant's motion. The Commonwealth opposed it.
You had asked who's arguing that for the Commonwealth. That's why
I'm sorry, defense motion.
Okay,
Okay,
that's fine.
sorry, I apologize.
I could go first if you'd like.
Excuse me?
I could go first if you'd like, whatever the.
I'm fine with him going first if you'd like.
Okay.
I think the heart of this motion is that the defense would like to introduce the ARCA witnesses as witnesses that were employed by the federal government. I think the reason for that is it creates the image or the projection that they are independent at the time they did their assessment and at the time they wrote the report. And then subsequently being employed by the defense has no impact on their objectivity at the time they did their investigation and report. I think this would be an unfair proposition for a number of reasons. It would undermine, as we hear today, the Commonwealth does not have an answer why this investigation was initiated, what the purpose of it truly was, the scope of it. We don't know every witness that may have gone before the grand jury. We do not know of all the communications between the federal government and different parties, including witnesses. We will, I expect, never have the full account between the state and what, if any, impact the defense had on ARCA witnesses at the time they did the investigation. What we know is it was a comprehensive investigation. We know that a number of experts were retained by the federal government, including the ARCA witnesses. What we also know is that there was an inquiry lodged by the defendant to the federal government to investigate her situation, her case. What we know is that the defense had the information to advocate respective case, including witnesses tasked to conduct an investigation, and they were given materials. Who decided what materials to give them? We do not know what materials in totality they viewed. We know many of the materials that they weren't given. And so clearly there is a undefined relationship between the defense and the United States Attorney's Office around this time of this investigation. And we subsequently learned that there was a continued on February 13th. Nothing. And we know just inherently from that information that there is more. There are more communications, there's more interaction. Witnesses get on the stand and then suggest that they were independently hired by the federal government and all of their attempts and efforts and report was wholly and entirely objective. Just to give one point that emphasizes the concern, the ARCA witnesses were never given information about DNA. And yet when they testified, one of the witnesses tried to think quite the opposite of what the defense would like to propose. And so in a vacuum, it would be misleading. I think what the court ultimately should do is they should present these witnesses as they did at the first trial. To that, the defense retain them if that's what they chose to do. We still don't know that because we don't have any Rule 14 discovery. A credibility issue will be the information they did and the limitations of, and ask them why they didn't ask for more information or why they didn't receive more information. Notably, we still don't have an answer to Mr. Klein, who was the third biomechanic person involved. And
Is his name on the witness list?
I haven't seen it on the witness list.
Yeah.
We still don't, the defense supposed to call 2 or 3. As you know, that report is vague. That came from. He is not held to the opinion in the report saying that we would have found DNA. He can simply defer and say that was somebody else. That could have been Mr. Klein, could have been Mr. Wolf. We don't know. So that report really is quite unhelpful. And I think we need answers to these questions before any of these witnesses testify. And I do not want to be moving during trial to exclude the defense witnesses for failure to comply, but we haven't seen compliance, and I don't think we will. So my suggestion is to follow the protocol of the last trial, but before that, these witnesses should be brought in so that we can obtain
Your Honor, the Commonwealth and the defense
I think Brennan is letting the special and special prosecutor go to his head. It's just a title, dude. It doesn't mean that you're special. It's not a. It's just a title. It doesn't actually mean that. You're short bus special, but that's yeah. Special prosecutor, it's a title because you're actually a defense attorney. Doesn't mean what you think it means.
trial, this court disallowed the ARCA witnesses from testifying about who hired them. We were therefore forced to ask oblique guide them with information that we didn't influence their opinions and conclusions, but we weren't allowed to tell the jury that the Department of Justice, the U.S. Attorney's Office, hired them. I think the court will agree that it's ironic in a way, excluded mention of the Department of Justice and the U.S. Attorney's Office because the court rightly did not want the jury to speculate about a federal investigation. But by excluding mention of the federal government having retained ARCA, the jury was left to speculate incorrectly about how they became involved.
They were also instructed more than once not to speculate, right?
But the point of the fact of the matter is, Your Honor, they did speculate. At least one juror thought that ARCA was hired by Ms. Reed's car insurance or home insurance company. And think about the implications of that. If Ms. Reed's insurance company had hired ARCA, they would have had a motive to absolve Ms. Reed of responsibility. That clearly would have adversely affected their credibility in the eyes of the jury, and unfairly so.
Let me ask you a question. If I allow, and I'd be very surprised if I did, mention that this was a federal grand jury and that the federal, how does that not open the door to all the testimony that Mr. Brennan just brought up that he'd be able to get into?
Okay, so first of all, and this is later in my argument, we're not asking.
So no, could you answer that now and then? I'll let you say everything.
Your Honor.
Oh, you just said it's late. Hold on, you just said it's later in the argument.
I know, but I said you interrupted me, and I was just about to say, but I'll address it now.
Okay.
Woo! Get her, you natty. Get her.
I'm not asking that the jury be told that there is or ever was a federal investigation. That phrase, federal investigation, never has to be part of this trial. I'm only asking that they be told that the Department of Justice or the U.S. Attorney's Office hired these witnesses.
Carla, you can tell they're lying on the stand. You'd have to be an idiot not to realize these people are lying.
That's it. We don't have to speculate about an investigation, whether there was an investigation, whether there was a federal grand jury, what that grand jury did, what that grand jury considered, nothing. That's not what we're asking. And the problem here is that without knowing that the Department of Justice or the U.S. Attorney's Office retained ARCA, the jury's left to speculate about how they became involved, and it all inures to my client's to prejudice my client. Thinking that they were potentially hired by an insurance company of Ms. Reed really perverts the truth in this case. It's unfair to my client, and it's the opposite of the truth. There was another juror that speculated that the ARCA witnesses were just attention seekers, looking to make a name for themselves in a high-profile case. That's also the furthest thing from the truth. They'd never heard of this case before the Department of Justice called them. That's how the Department of Justice wanted it. They wanted clean experts who would take a sober and strictly scientific look at the evidence. The federal prosecutors did not want them to be tainted by news reports or opinion pieces. And recall that the Commonwealth attacked ARCA on cross-examination for the discovery that they were not provided. That was patently unfair. ARCA should have been allowed to explain why they were given what they were given and who gave it to them. The inference is, and the Commonwealth suggested, that it was the defense that was playing hide the ball, when that inference is, again, the furthest thing from the truth. In terms of the information that the federal government got, Mr. Brennan engages in a ton of speculation about what happened or didn't happen.
Absolutely. I have never seen him yell at Bev before. I've seen Jackson do it. I've never seen Yannetti do it. That was a first.
Based on nothing. There's no affidavit to establish any of that. I will tell the court that I received a subpoena for my entire file from the federal government, and I complied with that subpoena. We had nothing to hide. We provided everything that the Commonwealth provided to us, to the federal government. They chose what to give ARCA or what not to give ARCA. And they did that again to preserve the scientific integrity of their opinion. So, again, we're just asking that ARCA should be allowed to testify that they want the federal prevent speculation about who hired them or why they became involved in the case. If the issue is we don't want the jury to speculate, the way to do that is to tell them the truth. We did not hire them. We did not influence their opinions. We didn't even know that, and all of this revealed to us that the federal government had hired these ARCA witnesses. And we read that information at the very same time that the Commonwealth read that information. Those witnesses, importantly, were available to be called by both sides. Contact them because the information was exculpatory. The jury should not be left with the impression that Karen Reed or the conclusions and opinions about what they were provided or what the relationship was or what the understanding was. That's all cross-examination material. He's free to explore whatever he would ask the court to issue a ruling that does not mislead the jury about how ARCA came into the case.
Okay. Any follow-up?
Yes. Respectfully, the Commonwealth does not look to hide the truth. The reality is, if the jury is going to hear information, they should hear the entire truth, not a version or a slice of it, not one advocate's side of the truth, the whole truth. And if we interject that these witnesses were hired by the federal government and the jury is entitled to hear the whole truth, then they should know the motivations behind the hiring, the input from the defense team prior to their decisions, and what, if anything, they considered and what their directive was. We don't have any materials from the federal government regarding direction, scope, purpose. We have nothing. Now, I didn't know that it was produced by letter February 12, 2024. We know from at least some of the materials we got, there's a document from attorney 2023 describing client's number of pages talking about the case. So it's not privy to. I'm not casting aspersions or trying to suggest there was anything improper about the relationship. I'm not suggesting that, but there was obviously a relationship between the parties that the Commonwealth was involved in. And so we can't take a fraction of something and say we just win. There was a purpose. There was an agenda, and it wasn't in the Commonwealth's interest, obviously. The ability to cross-examine witness only is effective, respectfully, is when they answered questions, but it was quite misleading, suggesting no relationship with the defense, talking about DNA with no DNA evidence. I do not think that cross-examining a witness, you should consider the witness a trustworthy guide unless they've established their credibility. I don't see that can to hold them accountable. Whatever it is their bias. And so simply cross-examining aimlessly is totally ineffective. It's a recipe for disaster, and that's not the type of examination we're going to engage in. If we're going to tell the whole truth, it has to be the whole truth. And I think that becomes a dangerous game. There'll be an entire days with these witnesses. It's unnecessary. It can be resolved through questioning these witnesses prior to trial and following the same protocol you did last time.
All right. So if the defense intends to call the ARCA witnesses, we need to have a voir dire next week. All right. So we're going to move on. I'll take this under advisement.
Can I just ask the parameters of that voir dire, the purpose of that voir dire?
Unless Rule 14 is complied with, it will be for the Rule 14 information. We can discuss this later. Let's move on, and I'll hear any objections later.
Why would you do that? Move on to the next.
All right, so the next motion is the defendant's motion for stating grounds for objections. I'll hear you on that, Mr. Yannetti.
Yes, I believe my written submission essentially makes the argument. As a result of our inability to state in, one or two words the basis for an objection, we had to go to sidebar far more often than we'd like to. And we're also conscious time away from their families, away from their jobs, and any sort of view that one side may be delaying the trial could engender some hostility from the jury. So, there were many times during the trial, I won't speak for my co-counsel, I'll speak for myself, where and the court made a ruling on that objection. And I had no idea what the court, we would go to sidebar, and the first thing the court would ask the Commonwealth was, what's the basis for your objection?
To make a record at that point.
Well, I understand, but it's, what's the basis for your objection? If it were that obvious that it could be ruled in open court, we should have known the basis for the objection. I didn't know
I
it.
agree with that.
And
You should have known the basis of you.
Well, I'm hearing it for the first time at sidebar. There were objections, evidentiary rules whatsoever. But in any case, this will avoid us having to go to sidebar multiple times. There were times when we had to sort of pick and choose when we went to sidebar because, again, we didn't want to engender hostility from the jury. My motion also points out, Your Honor, there's at least one case that talks about how an objection could be potentially waived if it is not stated with particularity. We think that this would, and look, different judges have different opinions regarding this. I've been in front of plenty of judges over my career who endorse speaking objections as long as there's no trying to coach a witness or, trying to influence a witness in any way. And that's not what we're seeking to do here. The objection hearsay, the objection lack of foundation, just standard basic objections There's no prejudice to stating them in open court. It will move the trial along more quickly. And we'd ask the court to change its ruling from the first trial.
Okay. That motion is denied. So the next motion, relevance, intend to put this evidence into the case?
We do not.
Okay.
So we can agree to that motion.
All right, so that motion's allowed, Ms. Giannetti. There's the defendant's motion for reconsideration of the March 6th court order. What I'm going to do with that is, if I can readdress that before rebuttal, before the witness is called. So we don't need to do this now. We'll wait and see what Dr. Russell's testimony is and if the Commonwealth's going to call the witness. All right, so we can address it later.
Thank you, Your Honor. And
Okay.
also, just so I'm clear on that, and to the extent we argue for the need for a voir dire, would that also be part of Your Honor's consideration?
So if I feel I need to reconsider it, that's the time to do it, after
Thank you.
Dr. Russell's testimony. All right, there's a motion, it's 599. Defendant's motion eliminate to prohibit the Norfolk District Attorney and Massachusetts State Police from having juror contact. So we don't need to belabor this. We talked about this before. No one has contact with the jurors other than the court officers. So defendant's motion eliminate to prohibit Norfolk DA and Massachusetts State Police from having juror contact. I'll also include prohibiting defense counsel and the media as well. No one is to have contact with the jurors. The court officers are the only ones that have ever had contact with the jurors. So I think now we move on to something that may take a little bit more time. The defendant's motion eliminate to exclude the testimony of Dr. Judson Welcher. How do you pronounce his name, Mr. Brennan? Welcher, and the Commonwealth's opposition. So who's arguing for the defendant, and how long do you think this might take? Because we can do some of the quicker Commonwealth motions if you want.
I am going to make the argument, Your Honor, and I estimate 40 to 45 minutes for this motion.
Okay. Mr. Brennan, how long do you think you'll take?
It's really dependent on what Mr. Alisi says, but I can't imagine it's more than 15 minutes, perhaps 10.
Okay. To appoint a stenographer, we've already done that. Prevent identification of jurors and impound the juror names during trial. Why don't we do a few of these, then we'll take the recess around 11, and then we'll come back with the lengthier motion. So I'll hear you on this, Mr. Brennan.
Thank you. Which motion, Your Honor?
It's to appoint court stenographer, prevent identification of jurors, and impound juror names during trial.
Commonwealth believes appointing a stenographer is a prudent practice.
We've already done that.
Okay. Preventing identification of jurors. This case is a case that has garnered extraordinary public interest. There are some concerns that in the history of this case, jurors have been identified by different characteristics, whether it's their hair color, their profession, and inevitably, as the trial progresses, it seems through sometimes the media, the jurors, although maybe not identified by name, have some of those characteristics promoted. That would cause, I would think, a strong concern by a juror that they're favored by one. That's the last thing I think anybody in court. before and during the trial. I think the jurors' names should be impounded. There has been past efforts by many to identify jurors, interview jurors, get information about jurors that is then highly publicized. That will chill, I think, the process of deliberating a fair trial for both sides. I think it is a measure that is accepted, it's appropriate, and under the circumstances of this case, I ask the court to do that.
Any objection from the defense?
Appointing a stenographer, impounding jurors' names and information, and in fact, we join in that request.
Okay.
The motion, however, also asks for the impoundment of all sidebar discussions. Before I address that, I guess I would first ask whether Mr. Brennan is pursuing that part of the motion.
I think that's a good question. Sidebar discussions regarding jurors.
Well, if it's sidebar discussions regarding jurors, we're in complete agreement.
So sidebars are impounded regarding jurors anyway.
So we're in agreement with that. I interpreted the motion perhaps incorrectly that Mr. Brennan was seeking the impoundment of all sidebar discussions regarding all issues.
It sounds like he is because of the fact of people listen to FTR.
Okay, well, that's what I'd like to
all right, so I'll hear you on that.
Thank you. So we do question the impoundment of all sidebar discussions.
Okay, you agreed to it last time, right? So this is a change.
This is a new trial, Judge.
Right, no, so just to be clear, this is a change.
I don't recall what we did or didn't do last time, but this is our position for this
Okay.
trial. Obviously, the reason some discussions are held at sidebar is to prevent jurors from hearing legal arguments on the admissibility of evidence. But this is otherwise a public courtroom, typically has a First Amendment right to know in Massachusetts what is going on in a public courtroom. And in fact, in Massachusetts, it's not just a First Amendment right, there's also a common law right to know what's going on in the courtrooms. And when justice is open to the public, it serves as a check and balance to the conduct of the parties and of the court. Consonant with these policies, in one of your recent rulings, Your Honor, the court recently cited to the strong presumption of Massachusetts law that a courtroom be open to the public. Therefore, there's both a state policy and a benefit to public disclosure of courtroom discussions and rulings. Of course, if there's something that is discussed at sidebar that involves...
Yeah, well, I don't think it's a coincidence that Aiden is sitting where the camera can see him. I think he knows we're watching him.
Information subject to a protective order. Portions of sidebars can be impounded. If there's some other reason for a sidebar conference to be impounded, the courts can so rule at the time. But a prophylactic blanket impoundment covering all arguments made at sidebar would sweep too broadly over these important rights and policies. There's a lot of publicly available information about this case already in the public domain. There are commentators who write and speak about this case every day on the internet. Sidebar discussions become yet another source of information, but the court's able to guard against the jury being influenced by extraneous information outside the courtroom by instructing them every day, as you did during the first trial, that they're not to read or watch or pay attention to anything about this case outside the courtroom. And in that sense, sidebar discussions are no different than the daily news about this case that is discussed incessantly. And for that reason, we believe they should be generally made public.
All right. So last time they were sealed, and that was by agreement of all the parties. So this time there's an objection. What is the authority for me sealing or impounding sidebars?
I don't have an answer to that. It's something I'll need to look into because it is a legitimate concern of the Commonwealth, but there needs to be authority. And I can't say right now I have authority for it.
Brennan!
I can tell you the concern is that many of the sidebars help vet out information that should not be heard by the jury. It's not the community that's the concern. Even the most diligent of juror in a trial of this magnitude and this length may hear extraneous information, whether they're looking at news reports or not. whether they're simply getting lunch. If there's evidence that is deemed inadmissible and prejudicial to the jury, that runs a real risk if the public hears the promotion of sidebar conferences. It's not an attempt to stifle First Amendment. It's not an attempt to deprive the community of the full value of the public trial. Rather, it is the concern that this case, unlike most or any, seems to have a political event component to it, and factions and sides and heavy promotion. It's a cottage industry in ways, unfortunately. And that creates an enormous amount of social media and media attention, which I embrace for the First Amendment, but we want to keep the jurors from hearing information that would be prejudicial or extraneous. And given the length of the trial and the heavy scrutiny in social media, that's the government's concern. But I agree the government should have a legal basis. If you give me an opportunity, we can offer the court whether we have that basis or not, but I can't tell you that now.
All right, so I am taking a lot of these motions under advisement. I'll give you until tomorrow afternoon.
Thank you very much.
Brennan, are you going to be prepared today at any point? How many times have they
Is there
told
an
Judge-
objection to 20 minutes, the Commonwealth's Exhibit 3, Motion 3, Commonwealth's motion for in-court identification? Is there any objection to that?
No objection.
All right, so that's allowed, Mr. Clerk. And the next one, Commonwealth's motion eliminate to admit the victim, 1 photograph of the victim, 2 photographs of the victim's injuries as observed by medical providers during the autopsy. Is there an objection to
No
that,
objection.
Ms. Little? That's allowed.
Show his perfect
Um,
legs.
578.
Please show his perfect legs.
So the manner of death, so that is on the death certificate. So this is your number 5, Mr. Brennan, paper 579, Commonwealth's motion eliminate to preclude reference to and redact the manner of death certificate. I'll
No.
hear you on that. Yes.
Don't allow it, Bev. Don't you do it.
Pursuant to Mass case law, Commonwealth versus Almonte and Wallace, as we've laid out in our memorandum, we would like to have the cause of death redacted from the certificate. Certainly, the defense can cross-examine any witnesses that are called regarding the manner of death, but this notation on the death certificate is extraneous and it should be inadmissible. General Laws, Chapter 46, Section 19, provides nothing contained in the record of a death which is reference to the question of liability for causing the death shall be admissible in evidence. Again, different when questioning a witness that is offering an opinion regarding the cause of death, but the certificate itself should be redacted and it should follow Massachusetts general laws and it should follow Massachusetts case law. And for those reasons,
That's law.
we ask the court to redact
That's
any cause of death in
stupid.
the death certificate itself.
All right, who's arguing this for your defense? Ms. Little?
Thank you, Your Honor. In this case, the medical examiner who completed the death certificate concluded that the manner of death was undetermined. The Commonwealth is seeking to exclude this information from the death certificate because it is exculpatory. The Commonwealth seeks not only to have the court redact the manner of death here, but they're also not calling the medical examiner in this case, which creates certain issues. All of the cases cited by the Commonwealth in this matter deal with the issue of whether it was error for the Commonwealth to admit a death certificate listing the manner of death without redacting the word homicide, because it violates a defendant's constitutional right under the 5th and 14th Amendments to the United States Constitution. That is not the situation that we're presented with here. None of the cases cited by the Commonwealth that were just referenced by Attorney Brennan stand for the proposition that a death certificate listing the cause of death as undetermined should be redacted. If the court looks closely at even the cases cited by the Commonwealth, specifically Commonwealth versus Ellis, I'd urge the court to carefully read that opinion, because what it says is that the SJC identified the words that best practice dictates should be redacted from a death certificate. And what the SJC said is this, and this is dicta, it's not even true case law. The better and safer course is to exclude from a death certificate the words homicide, suicide, or accident in a criminal trial. Notably missing from that is the word undetermined. And that's because undetermined is not a finding of liability. That is what the whole statute was meant to protect from. So there is no case law that suggests that the word undetermined should be redacted from a death certificate. The Commonwealth bears the burden of proof in this case. They have to prove beyond a reasonable doubt that a homicide occurred. And the Commonwealth's own medical examiner has opined that she was unable to make that determination in this case. That finding is relevant, it's exculpatory, and it should not be redacted from the death certificate.
So you say the medical examiner is not testifying?
It's not, I believe the medical examiner is not on their witness list.
Oh, I thought I saw her. Dr. Scorti-Bello? Oh,
Not on their witness list.
right.
Just number 81 on the Commonwealth's witness list.
All right. I'll take this under advisement. I'll take a quick look at Ellis again.
I would just note, I apologize. I know Attorney Brennan did represent at one point that they are not likely to call the medical examiner. So that was my impression.
Okay.
Perhaps I'm incorrect.
That's fine. Thank you. All right. One last, hopefully quick one. Commonwealth's motion to eliminate to introduce certified records from the Registry of Motor Vehicles. Is there an objection to that, Ms. Little?
No objection.
Okay. Probably one more quick. So that's paper 5E, Jim?
Thank you.
Commonwealth's motion eliminate with the intent to obtain query records of potential jurors. That's allowed as long as it doesn't disrupt the trial in any way.
May we be heard on that?
Sure.
Your Honor, potential jurors are asked when they fill out the jury questionnaire whether they have a criminal record. They're also asked if they know anybody in law enforcement. They're asked if they've ever been a victim of a crime. And for every other answer on the questionnaire, the parties must accept the potential juror's answer, which that juror is giving under oath on the form itself. In fact, there are times when a court may deny an attorney from inquiring further about a clear answer on the jury questionnaire, precisely because the answer was clear and it was given under oath. It is solely through the issue of a past criminal record that the Commonwealth seeks to question whether potential jurors are telling the truth. If someone claims not to know law enforcement, the Commonwealth is content with that answer. Does not ask for permission to conduct any further research. If someone claims never to be a victim of a crime, again, the Commonwealth is content with that answer and is not curious about whether the potential juror is telling the truth. In other words, it is the potentially hidden, if the potentially hidden information benefits the Commonwealth in their viewpoint, they're fine with that. The only way to make this process fair to both sides, therefore, with regard to this motion, would be to release to the parties the jurors' questionnaires in advance of trial so that each side can do their own independent research and investigation to vet the potential jurors in the pool. I know that there is case law to support the invasion into a juror's privacy regarding a check on the existence or not of their criminal records and a vetting of potential jurors' truthfulness. But it is interesting that the very first case the Commonwealth cites, the Hampton case, stands for the proposition that criminal records of prospective jurors are not an indispensable or necessary means to the selection of an impartial jury as a matter of federal or Massachusetts constitutional law. That was a case in which the defense had sought a query check of potential jurors, and the judge denied that request. And the SJC said it was fine to deny the defense's request. That means, Your Honor, that you would be justified in exercising your discretion to deny the Commonwealth's request to be allowed to invade the privacy of potential jurors, because pursuant to Hampton, it's simply not an indispensable or necessary way to select an impartial jury. Having said that, Your Honor, if the court is inclined nonetheless to allow the motion, we asked for an order that every bit of information turned up by the Commonwealth in their investigation of jurors be turned over to the defense.
I think that's the common practice of this office. What do you say to that, Mr. Brennan?
Is it the common practice of this office? Your Honor, is the court's question common practice of giving everything, or is the common practice of running queries?
It's actually seems to be both.
I believe I've been informed that it is the common practice, and that is the practice we would follow to give everything to the defense. I think the assumption that the Commonwealth would not want somebody with a criminal record on the jury might be misplaced. Somebody who has a criminal record shouldn't be precluded from jury service. In fact, maybe people who have a criminal record in re-entered society who the Commonwealth would embrace as jurors. But sometimes people forget or mistake that they have a criminal past. I understand may have happened in this case, has happened in many of my cases. And the nature of any past criminal record is sometimes helpful to see if there's an association between that and the charges in this case. So we would embrace providing everything to the defense and ask the court to allow our motion.
All right. If you remember, I give a catch-all to the jury that sometimes we're in a hurry to fill out these forms. Sometimes that when we get these questionnaires, we think, well, this situation may not apply to me. So I give them time before they come up. And I specifically say, perhaps your experience as a witness or a juror or a defendant in a criminal case, or if there's any prior record, things that you may have forgotten. If you didn't include it and you remember it, please tell us when you come to sidebar. And inevitably, every trial there's somebody that says they forgot to say something, or they had a record that, got in trouble when they were 17 or something. So it happens.
Right, and that's an argument against the Commonwealth's motion, because you're
But I
giving the
thought-
jurors a chance to correct what they put on the initial form. There's no need for the Commonwealth to do their own independent research to confirm or deny that.
All right, so you're asking me to flat out deny the motion, but if I allow it, you'll get the copies?
Correct.
Okay. All right, why don't we take the morning break at this time and we'll come back and we'll do that motion, the defense motion regarding Dr. Welcher.
All right, please.
You are muted.
Bev, you're so rude. You don't even say what time to be back or nothing. Yeah, the thing about the clothes or wearing any type of jewelry or whatever that represented the defendant, blah, 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 that was in the one about the buffer zone and the police being allowed to use physical force and arrest people. That was all in that. And they didn't even talk about that. They just skipped over that. I don't know if they're going to come back to that or what. You guys, pray for me. I got a headache again. It's not a migraine. And it's weird because it's it's across my forehead, but it's coming from my neck. The back of my neck hurts and my neck keeps popping. And then my front of my head hurts, which is weird. It's not the back of my head, but it's coming from my neck. I know it's coming from my neck. I have an appointment with my pain management doctor next week. So. Man, I had my hopes up about those about maybe being allowed to do speaking objections. Because that was annoying as hell last time. And everybody that was new and came in, they were like, why aren't they saying what they're objecting about? And we had to keep saying, because the judge doesn't like it. The judge ruled they can't do that. They're not allowed to do that in this trial. It was like every day somebody would ask. Every day we had to tell them again. Because I was a mod for that trial on Legal Bites channel. And every day we should have had it typed up and ready to go. So we just cut and paste it. Because every day somebody asked. I mean, that doesn't show bias. That just shows that she likes to be difficult. I mean, seriously. It would go so much faster and so much smoother if they could just say, objection, hearsay, overruled. And then just keep going. But no, objection. And then they walk up to the bench. And then they have to talk about it for 10 minutes. It's ridiculous. I did eat, but after my nutritious peanut butter and banana toast, I ate I ate Judy, you're not old enough to be my mom. I ate a half a pack of Peeps and 2 Cadbury eggs. No, I'm not talking speaking objections like arguing your objections. I don't like those kind of speaking objections. I'm talking about just hearsay, argumentative, speculation, facts not in evidence, those kind of speaking objections. I'm not talking about arguing like Carrie, what's your face? Morissey, was that her name? And Hannah Gutierrez, her and Hannah Gutierrez's lawyer, I mean, they would full on argue with each other in open court. That was ridiculous. And then the judge finally was like, no more. You come up to the bench. Those are speaking objections that are not allowed. But just saying objection, hearsay, that's different. And that can go faster if you... Did you guys not watch the Hannah Gutierrez trial? The Rust movie set trial? Oh my God, Carrie, that woman, that's why... Do we need to do a rewatch of that? Those two attorneys were going at each other in open court in front of the judge. Oh, yeah. It was ridiculous. And that woman, she was a special prosecutor too. She was a defense attorney that they hired as a special prosecutor, and she hid evidence. That's why Alec Baldwin got off. She did a Brady violation. She got Hannah Gutierrez Reed convicted. But the defense attorney in that case knew about the evidence and chose not to use it. But then when it came to Alec Baldwin's trial, that attorney was not allowed to have that evidence and somehow found out about it. And so it was deemed a Brady violation because it was evidence that potentially could have, although I don't think it would have, but it potentially could have exonerated Alec Baldwin, and it was not turned over to the defense. And the judge ruled it a Brady violation and declared it a mistrial with prejudice, and that's how Alec Baldwin got off. Yeah. The trial itself, well, I watched it because I was a mod on Legal Bites channel. And it didn't, the only reason it interested me, but not for what it was, it interested me because Jensen Ackles was in that movie. And he's on my list, y'all. He is on my list. and I thought he was going to testify. So, and one time, Carrie Morissey said his name, and I typed, I typed in the chat, "You get my boyfriend's mouth out of your, my boyfriend's name out of your mouth." I cracked everybody up. I'm like, don't you talk about my boyfriend. But bless his heart, he didn't testify. And he was so upset about what happened. They finished that movie. I don't know whatever happened to it. I don't know if it even came out yet. Or if it did, what happened. Like I guess it bombed if it already came out, because I haven't even heard anything about it. But Jensen Ackles refused to be in it after that, and they had to reshoot all of his parts with another actor because he refused to be in it. Oh, I agree. I totally agree. Yeah, just because watch that with me. That's how I found out he used to work in the movies. I was like, oh my God, I feel like such a bad friend. I've known you for over a year and I didn't know that. Yep, we watched it together. Yeah, I don't think anything was intentional. I think everything was accidental. It was just a huge accident. I don't think anybody meant to kill anybody. I think it was a total accident. And I think she should have been punished. I don't know if, I guess 18 months. I mean, in the grand scheme of things, 18 months isn't that long. Am I still quiet? What is wrong with my mic? I got it right up to my mouth. I'm right into it. I don't know what is going on. I had it plugged into my splitter, but then I unplugged it from there and plugged it right into the computer, thinking that was the problem. So I don't know what's going on. Maybe I need a new mic. But I always thought, and I know this is an unpopular opinion, but I always thought that Alec Baldwin was 100% not guilty because he just used the gun that was handed to him. And I know everybody said, I didn't realize that was paused. Are they back yet? Everybody.
His 12-page.
Oh, sorry, guys. Everybody said, yeah, but he shouldn't have had his finger on the trigger. Well, yeah, but he didn't know it was loaded. He didn't expect it to be loaded because it wasn't supposed to be loaded. And I know everyone's going to disagree with me, but sorry, guys. I had it paused. I didn't realize I had it paused.
Do before this trial, I won't have the voir dire of the ARCA witnesses next before they testify. And we'll give you until then to comply with all Rule 14 discovery and see where we stand. So we don't need to bring them here next week unless you may.
No, I didn't make arrangements. I just want to make sure that we're very well defined on what issue is before the court that would justify a voir dire. I just want to make sure, I don't think that's been clearly articulated. I just need to know what the parameter substance, but I need to know what we're dealing with for a voir dire.
Okay. All right. So what I need you to do beforehand is make sure that all Rule 14 discovery is complied with. And if it is, then we'll see. Okay?
Okay, so it's basically
Yes.
defined on Rule 14.
Yes.
Got it. Thank you.
Does that work for the Commonwealth?
My concern is if we have questioning of the witnesses the day before their testimony, and part of that includes the production of records, and they don't have the records with them.
So we'll need that, Mr. Alessi, okay? Well,
It said it lost audio connection again. Yeah, the weather used to trigger my migraines before I got my dock piercing, but it doesn't anymore. This is coming from my neck, I'm pretty sure, but the weather does still trigger my fibromyalgia. Yeah, this is true. And he is a jerk, and he was in control of everything, and he didn't know enough to be in control of everything. So I don't know why. I mean, I guess I'd rather StreamYard instead of completely crashing, just screw up the audio, because then I'm still here and I can still talk to you guys, and I don't run the risk of you guys bailing on me. But still, it's still aggravating.
My discovery motion extends beyond Rule 14. And the reason why is it includes the communication. I understand. Constantly, we'll have a court order motion that we filed that includes the request for this mission to show, and I don't want that to be overlooked.
all right. So talk to Mr. Leonard. I'd like to be able to take forward about the trial. And we still think.
At your honor's direction.
All right. Thank you very much. All right. So now we'll go on to your motion, Mr. Alessi.
Buckle up, because he's long-winded.
May it please the court. In my presentation today with regard to Dr. Welcher.
No, I was just wondering if you're going to tell me what you're going to tell me and then tell me what you've told me. Do you plan on doing this? Thank you. Go ahead.
In my presentation today, Your Honor, I'm going to, Your Honor has the documents in front of you that I'm going to be referencing. I'm going to be referencing the 140 slide presentation.
Okay.
What the Commonwealth has dubbed a report, which is approximately 12 pages of a letter dated January 30, 2025 from Dr. Welcher to Mr. Brennan. And I am also going to be referencing a case law that the parties have cited. What Dr. Welcher has submitted.
He is very, very thorough, and he likes to outline what he's going to say before he says it, and she doesn't like that. So she tries to shut him down before he gets there. She's rude. She's just rude.
is notable both for what is submitted and what is not provided. Gone extraordinarily well beyond not only his area of expertise in terms of what he has provided, but as remarkable is he has not provided any documentation of how his methodology is tethered to acceptance or any of the Daubert factors. And this, again, is a pattern of the Commonwealth where they provide, as they did with Dr. Wolf, as they have done with Dr. Crosby, they provide long CVs, long qualification lists, and then are completely silent on the tethering of the methodology Daubert factors. So that is the jurisprudential motivation for me to hit the case law with regard to why that deficiency is fatal to their burden of proof under the Massachusetts law. So I'll start with case of Canavan, the SJC's decision of 2000. And I am going to provide 4 parts of Canavan. Number 1, it's in head note 11. And this case was about, as the court may know, the Commonwealth, not the Commonwealth, a party proposing an expert that was commenting on, which was fashionable at the time, multiple chemical sensitivity. And the expert witness trying to state that an individual suffered from multiple chemical sensitivity. Here's what the SJC stated in response to the expert that was proffering that testimony, and it's extraordinarily close to what is happening with Dr. Welcher, what happened with Dr. Wolf and Dr. Crosby. The SJC said there was no evidence in the record to show that Dr. LaCava, that was the proffered expert, used a reliable methodology to transform his general finding of chemical exposure to his more specific diagnosis of MCS, multiple chemical sensitivity. Immediately after, LaCava referred to the, quote, literature as confirming the existence of MCS and asserted that based on the examination and tests he conducted, the employee had symptoms highly suggestive of environmental sensitivity. However, Dr. LaCava did not identify any specific studies that showed the existence of MCS based on specific symptoms and did not identify tests that can be performed to prove that the patient suffers from MCS. Skipping one sentence. Thus, the only evidence on this record tending to show that the employee suffered from MCS was Dr. LaCava's assertion. The purpose of the Lanigan test is to prevent an expert from offering testimony to a fact finder that is not based on a reasonable or reliable methodology. We cannot conclude that the expert's mere assertion that a methodology is reliable is sufficient to pass the Lanigan test, absent any other evidence showing its reliability. And I have used the Latin phrase ipsi dixit, translated into because he says so, or he said. And it's not my pejorative. That's the ipsi dixit, comes right and is used in case of Canavan. And that's what the SJC calls it when you don't tether a
That's a cool word. Ipsy Dixit. I like it.
methodology to a study or common acceptance. It's just that expert witness saying it. The reason I perseverate on this is because that's exactly what Dr. Welcher is doing in a 140 slide presentation. It's exactly what he did in his 12-page letter to Mr. Brennan. Nowhere in either of those voluminous documents does he mention one word about two things he did. He did an analysis. He has a purported methodology, just like Dr. LaCava in case of Canavan. He doesn't mention one study to support his methodology. Unless there be any concerns, the law is clear that the Lanigan analysis is applicable to medicine, science, and technology. And clearly, Dr. Welcher is in the technology area, and the Dalbert Lanigan analysis is referred to as the hard science. So he also, Dr. Welcher, conducted an experiment. And I'm going to treat that separately from the lack of a methodology. So I want to stay just with the methodology that is purported to be used by Dr. Welcher. So keeping on with case of Canavan, Dr. Welcher also is proffering to provide opinions on the medical causation of the injuries to the right arm of the deceased. It's clearly what he is doing. Here is what the SJC said about causation. It's head note 14, and they labeled the heading of it causation. The SJC said, quote, "There is no suggestion that the judge conducted a Lanigan analysis to determine whether Dr. LaCava used a reliable methodology to conclude that the chemicals and caused his italics in the opinion her to suffer from MCS. This was an error." They went on, quote, "Because understanding medical causation is beyond the knowledge of the ordinary layman, proof of it must rest upon expert medical testimony. Because and I'm skipping several sentences, because the judge below did not conduct a Lanigan analysis to determine whether Dr. LaCava relied on a reliable methodology to determine that chemical exposures caused the employee's MCS, it was an error to admit the opinion." In the concurring opinion of Justice Greene, he added an important point. I quote, "Further and perhaps more importantly, the application of the standard will make little difference in how an appellate court decides a hard science." The issue was, what was the standard of review? Is it going to be abuse of discretion? And the concurring justice said, in hard science, it really doesn't make a difference. But here is apt for what we're here for today. The goal of Lanigan, as was the goal of the preceding tests, is to keep unreliable or so-called junk science from fact finders, thereby reducing the prospect of the return of verdicts or the rendition of decisions with dubious validity. So I rehearse apt provisions of the case of Canavan because the SJC sets forth what the burden is of the proponent. And I know Your Honor has heard me make this argument before, but I am now providing the SJC decision for direct support, what I to first Dr. Wolf, Dr. Crosby, and now Dr. Welcher. Next case I provide is Commonwealth v. Meeks. And that is another SJC decision. And if I'm not mistaken, I think all of the cases that I'm providing in my oral argument are cases cited to by the Commonwealth as part of this motion. I'm not 100% sure with regard to Meeks, but I think it's a decision that they cite as well. And oddly, all these decisions favor the defense. So here is, I'm only going to need to read one part of Meeks, even though it's a very long decision of 2006. It states at 2006 Westlaw 423, and this is on page 53 of the Westlaw copy. Quote, at trial, this court will require the Commonwealth's firearm identification witness to provide on direct examination, et cetera, et cetera. Last sentence. Such discovery is essential to an effective cross-examination and therefore to a fair trial. And I've made this argument many times before about the prejudice to Ms. Reed from the pattern of the Commonwealth to provide experts, long reports, long CVs, completely silent on tethering the methodology to a study, etc. And the SJC points out that that information is essential to an effective cross-examination and therefore to a fair trial. And with regard to, that's really more apt to the experiment that Dr. Welcher apparently performed, not apparently did perform, it is presentation. And this is, there's painting someone's arm blue, painting a hand yellow, and then trying to use the results of that experiment to support some wayward theory as to how the SUV made contact with the decedent. There's no doubt that's an experiment. So it's important when I get to that experiment, what the legal standard is before such an experiment can be admitted in evidence and test under the Commonwealth v. Davis and Lanigan as to how an experiment could possibly come into court. So you've heard of the case, and I know Your Honor knows of Rintala. We've basically cited it for the proposition of qualifications, but substantively, we haven't talked about it. And I know Your Honor is well familiar with it, so I'm just going to summarize what's apt for our motion. What the High Court said there is that the precise question is whether Giulianelli, this was the paint expert proffered by the Commonwealth, possessed sufficient education, training, experience, and familiarity to determine forensically when and how the paint was applied to the basement floor in the victim's body based on the information he was provided. And a large part of Rintala was, listen, this person was a paint engineer at his company and he had a lot of experience in that. But what he really didn't show and didn't have was experience forensically addressing the question. And that was certainly a big part of Rintala. So the court, to that point, said there is a significant distinction, however, between what Giulianelli had done in the paint industry for over 20 years and what the Commonwealth asked him to do in this case. So the court went on and discussed the difference, and it said he also, this is Giulianelli, he also did not do any research on the topic or search for any academic or industry materials on this topic. So the court, with that predicate as to what was lacking, which is completely the same as what's lacking with Dr. Welcher in his experiment, the court said this, and this is on Westlaw copy 14, head notes 19 through 22. I quote, expert testimony also may be based on or informed by the results of experimentation. Skipping. The conditions in the experiments must nonetheless be substantially similar to those at the crime scene for the experiments to be of any value, and where new hard science is involved, an appellate court will always take a hard look at the trial judge's decision to admit or exclude the evidence. So here's what happened that's very apt to Dr. Welcher. Our analysis of Giulianelli's approach begins with the important principle that judges should closely scrutinize expert testimony where the testimony is prepared solely for the purpose of litigation as opposed to testimony flowing naturally from an expert's line of scientific research or technical work. There is no evidence whatsoever in the Commonwealth's papers that Dr. Welcher had ever performed this experiment as part of his line of scientific research or technical work. From all indications, it appears that he performed this experiment specifically and exclusively for purposes of this litigation. And that's where the SJC started. So they immediately said, if it's just experiment done this litigation, we right off the jump have a big issue with it. The JC then goes on with this very, very questionable area of experiments and said, rather than flowing naturally from his work, therefore, his experiments greatly differed from the work he ordinarily performed and the observations he had experience making in the key. And his opinions were developed solely to assist the Commonwealth's prosecution of the defendant, which from all indications appears exactly the purpose of Dr. Welcher. And here now to the tethering of the methodology to a study which Dr. Welcher does not do at all. The court said, footnote 31, because Gianelli conceived of and designed the experiments without any stated basis in existing science or literature, and because neither the Commonwealth nor the trial judge applied the Dalbert-Lanigan factors, it would make little sense to attempt to apply them here. The SJC said, we're not even going to go do this analysis because the proposed expert didn't cite to it. So we're not going to guess at what happened. And it then said, relatedly, and I'm quoting, the Commonwealth has not pointed to any basis in existing scientific literature or research for Gianelli's methodology or experience. Instead, it appears that Gianelli designed these experiments on his own without any guidance. Reading down below, quote, Gianelli's experiments also do not appear to have been performed consistently with basic scientific principles. We have no evidence in anything the Commonwealth submitted that the experiment of Dr. Welcher was performed in accordance with any scientific principles, because his report and the slide presentation is completely bereft of any citation to basic scientific principles. Next, the court said Gianelli did not repeat or validate any of his 6 experiments is also significant. There is 0 in the current record that Dr. Welcher repeated or validated his experiment. Nothing. That is the legal standard for experiments in the Commonwealth of Massachusetts. It's not the defense creating the standard. It's not the defense suggesting what the standard should be.
Scientific.
What I just read
too.
is a 2021 opinion of the S.
It's a scientific standard too. If you can't repeat a experiment, then it's not what's the word I want? Valid. It's not a valid experiment if you can't repeat it. That's a scientific standard. So no, it can't be the legal standard at all in any court.
JC. With those important legal precepts stated, I now turn to the letter, what the Commonwealth provides as, or calls a report, which is the January 30, 2025 document from Dr. Welcher. And I start on page 9 of that report. And if Dr. Welcher had adhered to his own standards about what a biomechanical engineer is to do, my presentation would be much shorter. So let's see what he said the role of a biomechanical engineer is, and then what he did. Because this goes to the point of him exceeding his the scope of his qualifications wildly. So on page 9, he said in the first full paragraph under numeral 11, he says, in the middle of the paragraph, my biomechanical engineering analysis is determining the effects of physical forces on the human anatomy. I have not made any type of diagnosis. He then goes down below, in 2/3 of the way down, he says, injury causation analysis is a multidisciplinary endeavor that employs objective medical and biomechanical data and analysis to determine whether a MVC caused a pathological condition or symptom diagnosed clinically. Continues, the entire body region will be covered under 3 of the 4 main branches of impact biomechanics, which are injury mechanisms, mechanical response, tolerance, and the biofidelity of surrogates. Thus, injury criteria are needed by biomechanical engineers to describe the relationship between one or more physical parameters and the injury they cause. These criteria usually take the form of a simple mathematical expression or a force or acceleration level. I couldn't agree with him more that that is what biomechanical engineers do. And he then goes on the next page, first full paragraph, I understand my current assignment in this matter is to analyze the available data in this case, including but not limited to the data in and damage to the Reed 2001 Lexus LX 570, and to determine the events that applied forces to Mr. O'Keefe that resulted in the damage to his body. Structural failures, fractures, injuries. I agree completely again. That's what a biomechanical engineer is supposed to do. And what is it that he's talking about with force acceleration? At the risk of getting a little too nerdy, but it's really important, what biomechanical engineers do is they apply Newton's second law of physics, which is force net equals mass times acceleration. That's the mathematical formula. Because biomechanical engineers want to know what's the force being applied, and when you do that, then you can then say, okay, is this force capable of causing this result? And if that's what Dr. Welcher had done, again, my presentation would be very short. But that's the setup that he says are his guardrails, his boundaries. Now let's see what he actually did in this cases where we have great objections. It's his conclusions and opinions, which take up about 1.75 pages only on page 10. Let's see what he did and how he honored or didn't honor his own standard. And I'm going to, hopefully to assist the court, identify what I believe should absolutely be disallowed from him opining on. Conclusion opinion number 1. I'm not going to talk about things that we aren't contesting. I want to go to the things that are clearly wayward and improper. 1C. He cites to Julie Nagel and occupants of Richard D'Antonio Ford F-150, Ryan Nagel and Heather Maxim, arrival in time outside 34 Fairview, not seeing anybody exit Lexus or damage to the Lexus. What he is doing is he is not only using, but he's trying to credit contested testimony.
So let me find out, do you intend to introduce that testimony, Mr. Brennan, through this witness?
I intend to introduce that testimony prior to Dr. Welcher testifying. If it's not in the record, he would not be able to testify to it, but if it is in the record, he can refer to it as part of his opinion.
All right.
That's a very apt question, and Mr. Brennan's answer underscores the issue. So what I understand completely the foundational evidence issue. I understand all of that. But the transcending issue is an expert witness can't use contested testimony because experts are not allowed to credit and talk about the credibility of witnesses. It's clear case law in every jurisdiction, including Massachusetts. And he does that throughout his report. And we've provided in our supplement correction the clear case law. I'm not going to go through it because I know Your Honor knows this. It's almost Hornbook law. So based upon Mr. Brennan's answer, it only underscores and establishes our concern. So 1C should be excluded. Now to 2A Romanets 3 and 4. Romanet 3, 2A3. No evidence light was broken at 1 Meadows Ave. When does a biomechanical engineer get to testify about a contested issue and say no evidence? That's not for a biomechanical engineer. And when he set up his own boundaries, he didn't talk that he was going to be looking at contested evidence. Romanet 4, 2A4. No fragments of taillight on or in snow behind O'Keefe Chevrolet. That's an evidence, collection of evidence, preservation of evidence, etc. It's not for a biomechanical engineer. Then he goes on to 2C. Testimony of Jen McCabe.
Oh, God, no.
That's his heading. Karen Reed stated to her, etc., etc. In other words, given Jennifer McCabe's testimony, and then he talks about what he believes Ms. Reed knew. That is not only trying to credit testimony, we've got now a biomechanical engineer that is going to be stating the Commonwealth's case for it. What is the biomechanical force calculation for talking about Julie Nagel, Ryan Nagel, Jen McCabe's, or frankly anybody's testimony? It's unprecedented. Now, continuing on page 11 at the top, and this is C Romanet 1:1, 42622 Julie McCabe, 42622 state grand jury page, etc. Grand jury minutes. It's testimony. It's testimony of lay witnesses. Inherently, he is crediting that testimony as truthful. That's not what any expert can do, let alone a biomechanical engineer. Number 3, the location and orientation of the laceration on John O'Keefe's right forearm and arm are consistent with the geometry and orientation of the right tail light of the Reed 2001 Lexus LX 570. So let's cut through the euphemism of orientation. What he is referring to is pattern recognition. He is saying that the pattern of the lacerations on Mr. O'Keefe's right forearm are supporting his opinion. Where is his qualifications to determine pattern recognition of a wound on a decedent? They don't exist. 4, and that should be stricken and not allowed. 4, perhaps the most egregious of all, and I respectfully submit what I've pointed out are incredibly egregious. 4, the totality of the evidence is consistent with the right rear corner of the Reed 2021 Lexus impacting, etc., of his head on the frozen ground. So there are several maladies with that statement. First, where is his qualifications to testify as to frozen ground? He's not a pedologist. He's not a hydrogeologist. He's not a geologist. He has no basis to testify in that regard. But more importantly is his phrase, the totality of the evidence. And if Your Honor now looks at what he considers to be the totality of the evidence, it is extraordinary. He is, and I will state each one, he is becoming a medical examiner. He's becoming a lead investigator. He's becoming a cell phone data forensics expert. He of individual witnesses. So he says the totality of the evidence is consistent with the right rear John O'Keefe and Mr. O'Keefe, et cetera, and of his head on the frozen ground. So what he's doing is he's now talking about cause of death and manner of death.
Do you intend to introduce that evidence, Mr. Brennan?
We'll be introducing evidence of frozen ground through Dr. Welch. Is there other parts of the,
Cause of death.
he would not be offering the cause of death. I think the spirit of the report is putting all the information together to see his observations, but I recognize that he's limited to his field. Hard ground and the cause of death are not within his bailiwick.
All right, thank you.
Again, appreciate that apt question, and I'm going to go into why there's still an issue. So I think it's best just to go through each one.
Sure.
Thank you. So 4A, he says and this is what he means by totality of the evidence. Cell phone data. Where is his qualifications to discuss cell phone data? That's a data forensics. We had obviously many moments I'm sure your honor may wish to not remember, but with regard to Mr. Green, et cetera, we went through a lot of issues about the expertise needed, the methodologies, the various tools. Where is his qualifications to talk about cell phone data? There are none. It's improper. So A in its entirety should be stricken. C, forearm lacerations 3 above. So that goes back to the euphemism orientation where he wants to talk about pattern recognition. And it's interesting that the Commonwealth vigorously contested Dr. Russell, and we all know her credentials on pattern recognition, but yet they're proffering a biomechanical engineer to talk about pattern recognition. D, air temperature and frozen ground. I'm understanding, if I understand correctly, that the Commonwealth is now stipulating to excluding that. And it's really the frozen ground aspect of it, of D. Then E, I'm sorry, Mr. Brennan.
I don't mean to interrupt. The frozen ground, we're not going to bring in. The air temperature is important because it talks about the density of the strength of the taillight. And that's part of the conclusion. So there'll be evidence before he testifies about the weather we expect. Okay. And you can rely on that to talk about how that might affect the taillight. But frozen ground, we agree, that would not come in through Dr. Welch.
We have no objection to the air temperature testimony of Dr. Welcher.
Okay.
E, hat line and fracture location consistent with fall and posterior head strike. Extraordinary. Even the medical examiner in this case wouldn't venture onto that. But that is clearly an example of what I'm talking about in terms of Dr. Welcher going well beyond his field. He's talking about hat line and fracture location. That's a wound to the back of the head. And to make matters worse, he makes clear fall versus assault. He's making a distinction between a fall and an assault occurring. We've contested Dr. Wolf on that issue. Now with regard to F. This is the wayward, undocumented experiment that Dr. Welcher conducted. F, Romanet 2 should be excluded. It says drop test conducted by me with a hybrid 3 falling backwards, measured heads, G's of approximately, et cetera, et cetera. That experiment I've covered in what the case law requires for him to show. There is zero support for this experiment. I went through in Rentola, I won't repeat it, of all that needs to be established before an expert can talk about an experiment. Dr. Welcher supports his experience with zero. This very experiment that he did, this drop test, has zero documentation of where the methodology for that is supported by science. Recall in Rentola, the paint person conducted an experiment and the SJC said, yeah, you conducted it. Yeah, you know, this is your area, but you've got to show all of these things, including where is this supported by the scientific method? What studies? Did you repeat this experiment to make sure that there wasn't an error rate of concern? Every single deficiency in Rentola is extant with Dr. Welcher. His experiment must be excluded if Rentola is to have any meaning in Massachusetts jurisprudence. G, Julie, Nagel, and Ford occupants. Again, what does he say? Pulled in behind Lexus and never saw anybody enter or exit Lexus or walk into 34 Fairview. He's crediting, again, testimony and contested issues with regard to some important issues in the case. Unprecedented that a biomechanical engineer gets to come anywhere near that. And we provided, again, the clear case law where in Massachusetts that's not allowed. And as egregiously, H, people inside of 34 Fairview on evening of 128, early morning of 129. H, Romanet I. John O'Keefe never entered 34 Fairview. Is there any more of a contested issue than that? But yet he's proposing to testify and state that. What biomechanical engineering principle is being applied there? The answer is none. Except for Karen Reed, everyone at 30 and outside 34 indicated John O'Keefe did not enter 34 Fairview. Even more egregious than H. Romanet I. So with regard to Dr. Welcher, I have, again, genuinely tried to assist the court with regard to blue penciling his report to make clear, based upon the case law, what is within his bounds and what is not within his bounds based upon his own stated parameters. And with regard to the case law about commenting, not being able to comment on a witness, crediting their testimony, Commonwealth v. Quinn, which we cite, says such testimony impermissibly intrudes on the jury's province to assess the credibility of the witnesses. So not only is Dr. Welcher beyond his qualifications, but he's intruding on the province of the jury. And the Massachusetts courts state such testimony, the kind where an expert witness assesses the credibility of another witness, could substantially influence the jury's decision about whom to believe. And lastly, and importantly, should the Commonwealth try to save this wayward part of the report by saying, well, you know, is he really directly or explicitly doing it? The Commonwealth v. Lopez case, and I quote, vouching for the credibility of a witness, here's the key part, whether explicitly or implicitly is impermissible. So I believe it's explicit for the reasons I've given, but even if the court were to conclude that some of his references to witnesses is not explicit what he's doing, it certainly at a minimum is implicit. So with regard to the experiment, the case law is clear as I have recited. With regard to this experiment prepared solely for the purpose of litigation, not repeated, not retested, no documentation in the scientific engineering literature for the methodology or the experiment, dooms Dr. Welcher's experiment. And the bases in the jurisprudence of Massachusetts couldn't be clearer. Experiments come to courts with an extremely jaded eye, as Rentola talks about. The eye both eyes get even more jaded when it's created purposely for the litigation. And what is clear from the case law is the prejudice to the defendant in these cases by allowing experts such as Dr. Welcher to stray into all of these areas. In conclusion, Dr. Welcher is not qualified to do anything more than what the ARCA witnesses did, which is talk about and calculate forces and then determine forces are sufficient to, and based on physics, are sufficient. So, Your Honor, we would request that because all of these deficiencies so infect all of his report, meaning the experiment is the entire basis for his opinions. You pull out the experiment, he has no basis for an opinion. You pull out a lot of his items, there is no basis for his testimony, and it frankly shouldn't be the job of the defendant or the court to fly spec his report in his slide presentation. And that is the final data point I want to hit, which is his slide presentation. We have a 140-page slide presentation that is unintelligible on its own. You can't understand it, and the report merely references it. It doesn't explain it.
Let me stop. Mr. Brennan, do you intend to use this PowerPoint presentation?
Parts of it. It certainly needs redactions. Any reference to witness testimony needs to be redacted. Opinions on credibility needs to be redacted. But there are different demonstrations that we do expect. The demonstration at Meadows Road, which clearly depicts that the cars didn't contact the taillight, we want to produce. The drop test, similar to ARCA's test, we intend to offer that. But as far as the extraneous commentary, no, that's not intended to be. It's not proper, and we wouldn't even try to.
Do you intend to use all 140 or however many?
No,
Yeah,
that is
now he
more
doesn't intend to use
comprehensive in
it.
the production to the defense, so they could see the data points, how it was produced. And so we've included, you see many of the slides is the cameras showing the different data downloads.
Now he doesn't intend to
Only a
use it.
fraction of that we would show. What we would show is the drop test, the demonstration of the Lexus hitting Mr. Welcher's arm. And also we would want to show the ways, locations based on the data that will be introduced through other witnesses and after it's been attested to and its reliability.
Okay.
If I may be heard on this?
Sure.
Thank you. I still don't know the answer to your question. The defense is entitled to know.
Right. So this will have to be provided to you prior to it's done.
And do we have a date so we can adequately prepare for trial, Your Honor, in cross-examination?
When will you have the redacted slides?
I can have them by Monday.
Okay.
And Your Honor, if we have an issue still, can we submit something to the court? Don't need another court hearing, but if Your Honor would like it, we're happy to do it just to get the basis.
Sure. So you'll get what you're entitled to, and which is just a narrowing down of what you already have. And then if you need to respond, you can respond and we'll take it from there.
Thank you.
Okay.
So in conclusion, Your Honor, the proffered information from Dr. Welcher is, in my experience, unprecedented. It is all-encompassing. It veers extraordinarily beyond his own stated boundaries. And even if he didn't state his boundaries, it's clear he's trying to perform roles, even with regard to what the Commonwealth has just said they're stipulating not to produce, still getting in extraordinarily to other disciplines for which there's no documentation. My last point is the point made by the Supreme Judicial Court. these experiments, especially of the insufficiency of Dr. Welcher, cannot be admitted into courts and go before juries for the reasons of the improper influence on the jury. And secondly, the methodology has to be tethered to a study or something in the literature to give the court, as the gatekeeper, a basis to say, this is science. This was done pursuant to the scientific method. And Dr. Crosby, Dr. Wolf, and now Dr. Welcher are completely absent with regard to that tethering. And as the SJC says, that deprives the defendant of cross-examination and a fair trial. And I don't know why the Commonwealth, I've been saying this for months, literally, as to why the Commonwealth doesn't produce it, either in reports or in their responses to our motion. I am left with one conclusion, Your Honor, and that is they don't want to provide it, and they want to, as the Commonwealth's favorite phrase appears to be, do trial by ambush. But that can't work with a defendant in a criminal proceeding. The Commonwealth can't ambush, and that's not my standard. That's the standard of the SJC. So we respectfully request that Dr. Welcher's report and his testimony be disallowed in its entirety. We will, of course, await the narrowing as Your Honor has ordered, and we would urge at a minimum that the defense know clearly what this witness is going to be allowed to testify to. And we would like to avoid an evidentiary hearing because I think it's pretty clear what the parameters are. But I have to reserve, Your Honor, our request in the alternative for an evidentiary hearing if what we get from the Commonwealth continues to be the vagueness that we've been getting all along. Thank you, Your Honor.
Okay. Mr. Brennan.
Oh, wait.
Good.
I'm particularly disappointed that Mr.
Oh,
or Attorney
boo-hoo.
Alessi sees this as some type of trial by ambush.
Boo-hoo.
I'm not going to digress the way he has, but a case study in that is the ARCA, and that's why I'm concerned about waiting until the day before trial to get simple Rule 14 discovery. ARCA and Mr. Welcher have some similarities because they're biomechanical engineers. Now, in our production, we gave over 8 gigabytes of information from Dr. Welcher. We gave any reference material, whether he was going to use it or not. We gave all studies, all data, anything that he can.
Oh,
but Dr. Welcher
make
gave his
me
entire
sick.
file to the defense with all of the raw material, all of the studies, all of the reference material. It's not limited to this report. As you can see, Dr. Welcher is extraordinarily thorough. You can see in the report all of the things far even considered in this case. And so it is obvious, but maybe not to the defense, so I will narrow it, that Mr. Welcher, Dr. Welcher cannot come in and talk about the opinions or testimony of witnesses as it relates to their statement. So for example, as Attorney Alessi points out, 1C, he won't be able to come in and would not want to come in and say that the witness did not see damage to the taillight. She'll testify to that herself, that there was no damage. In fact, all the witnesses did not see damage to that taillight. As to 2C, the testimony of Jen McCabe, that is for reference. Testimony of Jen McCabe is for Jen McCabe and the jury. He will not be offering testimony of Jen McCabe or offering anything that relates to it. Similarly, 2.1 regarding Julie McCabe and grand jury minutes, he won't reference grand jury minutes in the abstract, let alone the details of it. Number 4, he will talk about the weather if it is already in evidence. It's a proper basis for an expert, but he will not be talking about the frozen ground. Similarly, in 4G and H, this is reference material regarding Julie Nagle and the Ford occupants, they'll testify to what they did and what they saw. And the people inside 34 Fairview, even though every single witness says John O'Keefe never came into Fairview, that is left for the witnesses, not for Mr. Welcher.
Well, they lied.
And so the basic argument of the defense is that this biomechanical engineer should not be testifying using his principles and his education about demonstrations. What is suggested is that there's no evidence that he ever engaged in these demonstrations before, that they were exclusive for litigation, they weren't tethered to a specific study, and the methodology for each one is not outlined in a report. I wasn't sure if he was talking about Dr. Welcher or he was talking about the ARCA experts, because when I'm looking at the ARCA report, which apparently they're very comfortable with, we don't even know which witness did what. Importantly, when we look at the ARCA report, you have one witness who decided to build a potato cannon for no reason that we know of. No evidence that anybody threw a glass, but apparently it was a cool idea, he cited on the stand. That wasn't tethered to a specific study. That didn't lay out the methodology of the potato cannon. That wasn't repeated or validated. There was no specific literature that was referred to in that report. And yet, not only were they allowed to offer this evidence, it wasn't inappropriate. Now, it would be nice to know a little bit about the potato cannon, maybe a picture or a video or some specs on it, or maybe some details on how it actually operated. See, these are the things that Dr. Welcher provides to the defense. He doesn't just provide the information, the raw data, and the studies. He actually shows the demonstrations. He doesn't hide from his basis of his opinions.
Oh, they weren't hiding.
He shows and demonstrates them with videos and pictures and photographs, quite unlike ARCA, where it is just simply a conclusion based on just trust me. And so when you look at the production by Dr. Welcher, it is not comparable to the standard that the defense accepts for their experts. He is a biomechanical engineer. That is a combination and study of engineering and physics and science. And it also details medicine. He's not a medical doctor. He's not diagnosing an injury, but it includes all of those arts. Now, this is the same thing that ARCA says in their report. If you look at their report, they talk about the study and they outline what they believe.
Carla, it wasn't a potato cannon. They built a cannon to shoot the glass at the taillight during the first trial, just in case they were trying to find maybe an alternate reason for the taillight being busted. So they built a cannon because they were thinking, well, if they were fighting in the car and he had that glass in his hand, maybe he was mad and he threw the glass in anger at her taillight. That's why he keeps talking about the cannon, but it wasn't a potato cannon. It was a cannon that they built specifically to shoot a gun at the taillight.
I believe the study of being a biomechanical engineer is all about. In fact, one of the complaints by Attorney Lisi is Mr. Welcher's drop test. ARCA report on page 10, they do the very same thing, except that they don't show it. They don't actually demonstrate it. It's pale in comparison, but they give the conclusions and they give a chart. No different. And so there are no medical diagnoses by Dr. Welcher. These are his opinions based on a study of the evidence, and he goes to the extent of actually demonstrating those different assessments that he has made. In particular, the defense takes issue with basically everything he's done. And just as a general perspective, they would like the ARCA witnesses to come in and say that the injuries were not consistent with striking the taillight of the Lexus. That's what they want to say. Dr. Welcher's opinion is different. It's the same engineering, it's the same science, it's the same concept. It's just a different opinion than they like. So if they like the opinion, all of these standards that Attorney Lisi is insisting on are excused, but if they don't like the opinion, somehow should be excluded. They're really polar opposites when you think about the perspective and the opinions they give. They both have a different opinion about the taillight causing the injury to Mr. O'Keefe's arm. One the defense likes, one they don't. It is the same science, same study, same analysis. And so if it's acceptable for ARCA, it must be acceptable for Dr. Welcher. Dr. Welcher actually downloaded the text stream data. He didn't ignore it. He didn't know that it didn't exist. He didn't fail to consider it. He actually downloaded it himself. He is experienced. He looked the material, studied the material. The text stream data is critical in this case because it shows time and place with the new information that we have. So we know from the Waze information exactly where that car went from the waterfall to the flagpole. We know where it didn't stop along the way. We know, based on the phone data, Mr. O'Keefe's phone data, when he was in the car until. We have all that evidence, and as a bioengineer, he can consider all of that technical data, which will be introduced through other witnesses at trial before he testifies. And it's important. The location and timing of that car is important. This is all science and data. It's not witness testimony. It's science and data. And it puts that car at that flagpole at the time Mr. O'Keefe is there with his cell phone, locked into the Bluetooth in that Lexus until he gets out of the car after 12:30. And within 2 minutes, we allege this collision occurs. And there's Apple Health data, there's location data, there's cell phone battery temperature. It all coincides. He should be able to consider these things in his study. This is what he does. The demonstration at Meadowbrook, John O'Keefe's house, is depicted by measurements which has been provided, science and data, by the ring videos, which will be independently admissible. And we see the gentle nudging of that Lexus into Mr. O'Keefe's car. And there has been allegations, claims, suggestions that that's where the taillight may have broken despite the other contrary evidence. You can see in the presentation, he actually shows not only the nudging and the car leaving through the ring video, but analyzes it, and you can see exactly where those two cars came into contact, and it wasn't the taillight. You can see through his demonstration or through his study of the materials he presented that the snow is on the back of Mr. O'Keefe's bumper until the nudge, and you can see the exact spots where the snow comes off. This is science and data. This is an opinion. This isn't witness testimony. And the jury should see that very evidence. It'll be admissible not only through him, but through independent witnesses.
Yeah, and somehow they magically lost the footage of her showing Jen McCabe and Carrie, what's her name, her broken taillight. Because that's why they took Jen McCabe's car when they went to look for John. Because she was afraid to drive it with a broken taillight because she thought there'd be a short or something and catch the car. I don't know. Catch the car on fire. She's weird. She's weird. That doesn't mean she killed anybody. She was afraid to drive the car because of the taillight being broken. And that's why they took Jen's. So it was broken when she hit his car that morning. They're idiots. Stupid. But yeah, that footage mysteriously disappeared.
The defense takes issue with Dr. Welcher providing an opinion that the lacerations and cut.
How can you say that when we don't know where he was when the car supposedly struck him? Or if the car even struck him? How can you say that? Roberts, thank you. How can you even say that? how can you say it's consistent with this taillight? The injuries on his arm are consistent with the taillight when you don't even know what position he was in when he was hit, or if he was even hit. That doesn't make sense.
But if you've seen the PowerPoint that's been presented and provided to the court, be presented to the jury, it shows the symmetry of the arm, the height of the broken taillight, and it shows with great continuity the height, location of that broken taillight, and how it relates to a bent arm. And that is based on engineering, biomechanics, the same things that ARCA employs. They just didn't do this. And so that's not witness testimony. That's not beyond the bounds of anything. That is powerful evidence, and we intend to introduce that. And then, as I mentioned, finally, the drop test. This is the same information that ARCA proposes in their report. For some reason, I don't think that was offered as evidence at trial, but it's clearly within the bailiwick of this expert. And so we will file on Monday a PowerPoint presentation redacting all the inadmissible parts of it, which is witness statements. And we expect to present the demonstrations to support the opinions as corroborative evidence of those opinions rather than just naked opinions. And there will be no trial by ambush. Now, we will be studious in getting that information to the defense. We would like them to be as studious getting us the ARCA information. It does concern me delaying the information because Attorney Lisi eloquently said, you need time to prepare. We know he's a very prepared attorney. We'd like to prepare as well. And if we wait to get records and information and know who wrote what part of the report, we won't be prepared. There's a third engineer in their team that wasn't called. We'll have to add him to the witness list if he has any relevance. We won't know until we question those witnesses. So I think I'm also inclined to ask the court to consider we have that questioning well before their testimony. But we will come in and provide those slides on Monday.
All right. And Mr. Alessi, again, you've already said you agree to talk to Mr. Brennan about the reciprocal discovery.
Yes.
Okay. Sure.
Thank you.
Like with Dr. Welcher's report, what Attorney Brennan did not say is even more important than what he did say moments ago. He didn't state or even address where is the methodology employed by Dr. Welcher tethered to a study, the scientific literature. He kept using the phrase, it's science and data, quote. Someone alleging that it's science and data doesn't even begin to approach that the methodology is established in the literature or satisfies the Dalbert-Lanigan factors. So, Your Honor, on the record before you, there's no better evidence that that tethering doesn't exist than the absence now for the fourth time upon challenge of that in Attorney Brennan's comments. That dooms Dr. Welcher. Now I want to address the false equivalency argument of Attorney Brennan. Attorney Brennan said falsely just now that the ARCA report does not set forth the methodology. There are 14 footnotes in the ARCA report. I just looked at them again. Footnotes 1, 2, and 3 tether the methodology literature. The methodology is documented. I do not understand how an attorney can get up and say a report doesn't have something without having a basis for saying it.
Because he's a lying liar that lies. That's why.
On a key issue that is disputed. Attorney Brennan also falsely stated that ARCA did exactly what Dr. Welcher did with regard to medicine and medical issues. That is completely false. ARCA, as is clear as day from the report, and I'll repeat it, did a force net equals mass time acceleration calculation and said the forces that come from 15 miles an hour, 24 miles an hour, and then so the unknown is the force, the F in the calculation. What is known is the M and the A. The M is the mass of the head and the mass of the arm. The mass of the head is 11 pounds. The mass of the arm is 11 pounds. You then take the acceleration theory, even assuming the theory of the Commonwealth, which we can test, which is it's 15 miles per hour or 24 miles per hour. You multiply the mass times the acceleration, and you get a force. And then they said this force is expected to cause or not cause these types of injuries. That is a proper biomechanical engineering analysis. The ARCA experts didn't get into pattern recognition with regard to the wounds, the orientation, etc. But most importantly, there is no equivalency between what ARCA did and what Dr. Welcher did. With regard to Mr. Brennan stating, quote, this is what he does, referring to Dr. Welcher. The question is not, is this what he does? The question is what he does rooted in science. And what it means is not just any science, it has to be a commonly accepted, his methodology commonly accepted or satisfying the Dalbert factors. And Mr. Brennan did not contest one aspect. He didn't say, Your Honor, here is where what Dr. Welcher did can be found. It's commonly accepted, either in court opinions, which the court could take judicial notice of, or in peer-reviewed literature, because it's not there. And with regard to the 5 non-exclusive Dalbert factors, I covered that in my presentation in the beginning. I'm not going to repeat it, only to say that Mr. Brennan didn't address any of those 5 factors to show a proper foundation for that. With regard to what Mr. Brennan called arm experiment, relating to a bent arm, relating to injuries, I understand what Dr. Welcher did. The question is not what did he do, but is it accepted in the medical literature? So with regard to the arm experiment that Mr. Brennan just went through, he talked about it, but he didn't mention once where that's rooted in the literature. He finally concluded by saying, this is within the bailiwick of Dr. Welcher. I don't know what this is, but bailiwick is a tautology. It doesn't say anything about whether what he did is rooted in the literature or that it satisfies the Dalbert factors. So in conclusion, Your Honor, I go back to Rintala, I go back to Meeks, I go back to Case of Caravan. The Commonwealth has not today, not before, this is their 4th time, has not satisfied what the Supreme Judicial Court requires in these instances. And what it has come down to is the defendants, which stands in a different position, this equivalency between ARCA, I've shown, and it's easily documented, the court can see it, that contrary to Brennan's false statements, ARCA did cite to and tether their methodology to the literature. But when you have a defendant on trial for the seriousness of the charges here, to have no methodology, to have no tethering to the literature, that's, as Your Honor knows, the gatekeeper's function to stop that those opinions from the Supreme Judicial Court has created, which is the purpose is to allow for and fair trial. There have the preponderance burden, and should be borne by the Commonwealth, not the defendant.
Okay, go ahead. I'll hear a quick response.
I know Attorney Morissey has decided to join the fray of disparagement. Now, he has said 3 times that I fall. This is the first time. Mr. Has tried to portray the Commonwealth as dishonest because you know full well this is being covered by the media, and they want to create a sense to dehumanize anything that they don't like, whether it's the government,
Darn it, StreamYard. I wanted to make sure I was still paying attention.
it's like false statement. As an officer of the court, they better be supported. That is a strong case. He's joining the fray, and that is all part of the strategy here. Now,
The truth.
if you look at page 13 and 14 of Dr. Welch's report,
Liar.
different items of resources. And so if we're talking about support and tethering, it is at the end of the report. It's not footnoted.
Damn it. StreamYard? You were going good. You were cruising. What happened? You're just a stupid party pooper. See, this is why Recovery Addict doesn't want to cover this case anymore because of this. It's turned into drama more than law. And it has. And I think that this is exactly why DA Morissey hired Brennan, because he'll do the shady stuff. It's disgusting.
There's something you need more time on.
15 to 20 minutes, Your Honor.
All right, so we're going to have to table this. We may end up coming back tomorrow.
I can do it unless you tell me what
No,
Your Honor's
let's see what we can. 585. It's the Commonwealth's number 11. Motion eliminate to admit the victim's out of court statements relating to John O'Keefe's state of mind, the quals, types of cases. So is there an objection from this on that? If there is, I'll hear it quickly from the Commonwealth on its motion.
There is, Your Honor.
Okay, so I'll hear you on this, Mr. Brennan.
You knew that, Bev. It's a no-brainer.
Evidence of Mr. O'Keefe in this
Bye,
case.
Carla.
In addition to the charges, this has a domestic aspect to the case. We know from his statements that he was in a relationship with the defendant. We know from the statements that there was a tumult in that relationship, and many of those statements are reduced to writing. The state of mind of Mr. O'Keefe is reflected in those statements. There was no time or reason to fabricate. You can tell by the content and the volume of them that there is a legitimacy to them. And there another testimony that in the course of attempting to end the relationship with Miss Reed.
No, there
And so
was
his
not.
statements, especially over the course of the day of this incident.
All right, so what's the time frame? It's so over the course of the day, I realize that the Aruba incident is too remote and you're not using that, but what's your time frame for me to be able to evaluate
As
this?
far as his messages,
Sorry.
I will
Or
look.
the statements or the evidence that you're trying to put in under this
Sorry, Lord.
doctrine?
His niece would testify, as she did in the last trial, about the tumult in the relationship.
Okay.
And we'd introduce the same text messages that we introduced at the last trial, reflecting Mr. O'Keefe's state of mind about the relationship.
Then why did every freaking couple at the bar that night say that they were all lovey-dovey, hunky-dory? Why? Why? All couples fight. She was a clingy person and very insecure. But, oh my God. Oh my God.
Okay.
And there would be nothing different from the last trial, other than the fact that we are not going to. There's actually a narrower time window than before.
Okay. All right, I'll hear you, Mr. Jackson.
Thank you, Your Honor. I may be a little more brief given that explanation by Mr. Brennan than I intended or anticipated. I will say that where the Commonwealth's motion fails is in its explanation as to the relevancy and how it comes in under a state of mind theory. These are obviously hearsay statements. In some cases, they are multiple hearsay statements, or potentially multiple hearsay statements. John O'Keefe's state of mind is irrelevant unless there is a specific admissible evidence that he communicated those statements, and we'll have to sort of take them as they come, given I don't have the full breadth or an understanding of the full breadth of the information that is being sought. Brennan indicated it's going to be consistent with the last trial, so that gives me some target range. But without knowing more, under a normal hearsay or even state of mind analysis, it's irrelevant unless there's a specific admissible point that he communicated that, or point at which he communicated that state of mind to Miss Reed. She was aware of his state of mind, and very importantly, that the information that was communicated to her was of such a nature that she would have acted on it in a manner that's consistent with
What we were talking about, the bins, calls, those points.
correct. That's what I'm with that last point to drive this idea. There is no evidence to support that last point, that this type of information, let's say, for instance, it's information that he wanted to break up with her, or he was mad at her, or he was angry at her about something, some incident, some specific thing, feeding the kids donuts or not feeding the kids donuts, or they had a what was considered, what was testified to in the first trial as a very normal row or argument about something as insignificant as that. The fact is, the state of the evidence is that on the night in question, it's uncontroverted by even the Commonwealth that the two of them were getting along extraordinarily well. The facts are borne out in both videos that are uncontested. They're borne out in witness statement that went uncontested, that they were affectionate, they were happy together. They were described by basically everyone on the Albert side, the McCabe side, as well as individuals who also saw, that were not related to those families, who also saw Karen and John interacting throughout the evening. And they all said that they were getting along very, very well. One person described them, the court may remember this phrase, as lovey-dovey. I think that it's pretty clear that through this testimony, or through this rubric of bringing in John O'Keefe's state of mind, the Commonwealth really wants an opportunity to call one or more or several witnesses who will basically say he wanted to break up with her, she was not a good girlfriend, he didn't like her. That is an assassination of her character. Couch it in whatever terms he wants, but that's really what it is. These witnesses will have no corroboration, we expect. I'm leaving the text messages aside. If there are text messages between John O'Keefe and Karen Reed, that may be a different analysis, but certainly where it comes down to the witnesses, like the niece, they'll have narration or documents, no writings, no recordings, no videos, no audios, nothing but their word. And to allow a witness to walk in and to say negative things about Miss Reed with no way of verifying those statements is highly prejudicial. It's not just prejudicial, it's far more prejudicial than it would ever be probative in this circumstance. Even if he did, even if the evidence was that he had discussed breaking up with other people, there are two major impediments to the Commonwealth's request. First, there is no evidence that, for instance, from the niece, I don't believe that there will be evidence, that was imparted, or those specific conversations were imparted to Miss Reed. The state of the facts very clearly show the opposite. If we look at the circumstantial evidence, the videos of Miss Reed at both C.F. McCarthy that night, as well as at the waterfall that night, show the two of them getting along, completely inconsistent with two people who were talking about breaking up. John O'Keefe wanting to dump her and her knowing that, really suggesting. And second, there's absolutely no evidence that even if she thought that John O'Keefe, if she was aware that John O'Keefe was unhappy in the relationship, that he might want to break up or in the relationship, that would have been a catalyst for murder. And that's where the rubber meets the road in this analysis. That's what the Commonwealth has an obligation to prove before this evidence is admissible. And that's a ridiculous stretch. They'd been together for about 2 years, notwithstanding the prior relationship many years earlier. She had her own career. Karen Reed had her own money. She had her own life. She had her own job, had her own house. She was not dependent upon John. They were, at the end of the day, just dating. The fact that she had some text messages with other individuals, or an other individual, Higgins, is actually evidence that she knew she had options, and John O'Keefe likely knew he had options as well. Both of these individuals were not tethered to each other in a way that if one wanted to break up with the other one was going to murder the other one. And that's what the Commonwealth would have to prove to make this admissible. There's no suggestion in the facts that Karen Reed would kill John O'Keefe rather than simply break up with him or allow him to break up with her, and they both go on their own way. It's absurd. And there's no evidence that she was angry with him that night before she got out of her SUV. All of the evidence that we have, all of the uncontroverted evidence that we have, establishes exactly the opposite. They were a loving couple, out one evening, having drinks with friends, in a good mood, and happy with one another. We cite a case called McGraw, M-A-G-R-A-W. And just for the record, I'll state the site. I think it's at 426 Mass 589. And the McGraw court provided a very defined quote that I think is illustrative for our purposes, Your Honor. Quote, "A murder victim's state of mind may be material to the defendant's motive, but only if the defendant knew of the victim's state of mind, and most importantly, the court's words, not mine, and most importantly, would be likely to respond to it. The best evidence that this second prong cannot be met is the fact that the Commonwealth will attempt to bring in these prior statements of John, which, if believed, Miss Reed never acted on. In other words, they're going to bring in prior statements to say she would necessarily act on it and act on it in a violent way that would take someone's life. But at the same time, they're stuck with the very clear fact that if in fact that's true and it was imparted to her that he was unhappy in the relationship, she never acted on it, not once. And the moment that we do have frozen in time that we can go look back on is the night of January 29th, or the evening of January 28th, going into the early morning hours of January 29th, in which they were both getting along perfectly well, completely in opposite of what the court in McGraw defines as necessary for that sort of evidence to be admissible. The reason that the Commonwealth's theory for admission doesn't make sense is because it's not really their theory for admission, I suspect. I suspect that it's more that they would like to have someone or some people get on the witness stand and assail Miss Reed's character, make her look bad, and say that she was either a bad girlfriend or that John was not happy with her. It's an attempt to inflame the jury, to make them dislike her for something that has nothing to do with the evidence that she hit him with her SUV on the night in question. And it's a very transparent attempt. We strongly believe that this attempt does not meet the evidentiary standards that are required. The Commonwealth cannot meet those standards, and pursuant to McGraw and its progeny, we would ask that this evidence be deemed inadmissible.
Okay. Quick follow-up.
It seems the thrust of the defense argument, and I appreciate their advocacy and argument, but it's not shared by the Commonwealth, is that they were lovey-dovey and got along well that night. Well, at the time of this incident, it seems there's substantial evidence that Ms. Reed was not happy with Mr. O'Keefe. On 2020, transcript page 43, line 1, she was asked, would you say that you were angry with John that night? Her answer was yes. She was asked by Ms. Voss on June 20th, 2023 about that night, or the day before, and she says, I was temporarily frustrated. It wasn't an argument. She also says to Ms. Voss, were you worried at him or pissed at him or both? I was pissed until I fell asleep. Now, in addition to her anger, she specifies some of the tension. We heard from the testimony.
She was pissed because he was supposed to come back out and tell her whether or not they were going or staying. That's why she was pissed. It had nothing to do with their relationship.
Of Jen McCabe, that when she gave directions to John O'Keefe, she mentioned a mother of a child who Mr. O'Keefe had a prior relationship with. That this is minutes before we allege the collision happened. And so in the interviews that she has provided to these different outlets, she discusses and that there was an issue or some type of interaction about the fact that he was previously dated another woman. And this is a conversation that takes place minutes before the collision. And so from the defendant herself, that show the discord in the relationship, the anger, being pissed.
So she killed him because he used to date somebody else. Yeah, that makes sense.
Motive. Without reading them, because it's unnecessary, there is substantial corroborative evidence. Not only that it's corroborated by the niece's testimony, but the imminency of it. And this is real time moment for John O'Keefe's death. And so all of this should be admissible. It's all supportive of each other.
If I could just correct the record very quickly.
Sure.
If anything you just said was true, we might have an argument. Facts right. You got to get some of them right. The conversation that he just referenced with Jen McCabe was the next day. It was the next morning. Every time he stands up, he says, I wasn't there, I read the transcript. We got to hold him to that burden, Your Honor. You got to get the facts right. That conversation with Jen McCabe was the next morning after John O'Keefe had been found, after he didn't come home. I'm sorry. I was talking to my client real quick. I'm not quite done. 5:07 after the search for him. That's the point at which they have been at the time. It's after the fact, well after the fact. The other issues concerning Karen Reed's statements about being upset, or in Gretchen Voss's words, were you pissed at him? It was in context of when. When were you upset with him? When he didn't come back out, when he didn't come back to the car. After she left, she was angry. That's where all the voicemails take place. That's what she was talking about, having been angry. There is whatsoever no evidence in the record. I want to make this as crystal clear as I can. No controverted evidence, no suspect, no evidence at all. That John O'Keefe and Karen Reed had a single crossword that night before he ended up missing and she went home. Before he ended up walking out of the car, going toward the house, and she ended up leaving when he didn't come back out. Zero. The only evidence that was propounded throughout the was hours earlier that morning dealing with, did you feed the kids donuts? And yeah, I did. You know, I don't like it when you feed the kids donuts. She was spoiling the kids. It was not enough to enrage anybody. It's ridiculous. And the evidence that it didn't enrage anybody is the fact that they ended up later that night together in a lovey-dovey environment, getting along fine, getting along wonderfully. That's why the Commonwealth cannot make their burden to establish that this was the type of information that she would have, by necessity, acted on, and not just acted on in any way, acted on in a way that's consistent with their theory that she would have received the information and murdered him for it. That's the hurdle over which the Commonwealth cannot leap for the admissibility of this type of evidence. It's far, far more prejudicial than it is probative.
Okay.
Before accusing somebody of getting it wrong, the person accusing should be right. I know that Mr. Jackson, Attorney Jackson, not the next morning, when Jen was navigating John to the Alberts, she said it's near Ashley's house. Ashley and John had hooked up prior to John and I dating. Similarly, page 92, line 1, totally contrary to what you just heard. Totally. There was a woman who was a mother to kids that were close to John's kids who lived very close to the Alberts. In fact, when Jen was navigating John to the Alberts, when I was driving, she said it near Ashley's house. Ashley and John had hooked up prior to John and I dating. She broke up briefly with her husband. Not my words.
All right. So we're going to break. We've got a lot of ground to still cover. I suggest that we take the personal attacks completely out of this. Hold on. Both sides. I want to get through these motions today. If we don't, I'll bring you back tomorrow. I'll bring you back Monday. Let's get through these motions. Leave all the attacks, all the falsehoods, all of that. Leave it all aside. Let's focus on the motions and get through this. So I'll see everybody at 2 o'clock.
Your Honor, if I could say one more thing. As the court ponders this last issue.
I'm not even thinking about it for the next hour. Let's leave it. You know.
Oh my word. Okay. I believe Jackson with all my heart and thought that I was mistaken because I thought I had heard that they did argue in the car before they got there. But I could have been wrong. But then unless Brendan read that, so now I'm second guessing myself. I didn't take notes the first trial because I was mourning. And then that's like next to impossible. So just because says she didn't find that out until the following morning. I thought that's why she was mad that he wasn't home, because she thought he was at that girl's house, or that woman's house, excuse me. But okay, guys, I have some errands that I have to run. Oh, music. Yuck. Okay, I have some errands that I have to run. A Hunter look? Who's Hunter? I should know who Hunter is. Should I know who Hunter is? I don't know. Okay, well, I have some errands to run because my husband, bless his heart, he does not know how to use an ATM machine. And I used to try to make him go to the ATM and then call me, and I would walk him through it. But he still gets really aggravated, so I'm not going to make him do it this time. So I have to go get some money out of the ATM, and I'm going to mail your baby Yoda, Judy, finally. Oh, she didn't know the context. Oh, okay. Okay. Why did I think that's what they were arguing about in the car? I thought they had an argument in the car for some reason. Was that just about going over there, or did that not happen? Why did I think that? Okay. Well, anyway, I have to go run some errands, and I am gonna get me a protein shake and a healthy tea thing. Maybe that'll make my headache go away. It's not bad, but. And I'm gonna try to find me some all dressed chips. Man, I was so excited. Last night on Big and Streams, Bill Rhodes said, was it last night? Night before. Night before. Bill Rhodes said that Lay's was for a limited time selling all dressed chips in America. And I was so excited. And I ordered them for Walmart for pickup. And they're already sold out of them. Oh, I didn't watch the Maya case because I was a pediatric nurse and I didn't want to get fuming mad like I'm getting today. Oh, you guys, please watch this trial with me. I'm a screamer. I realize some people don't like that. But I'm a screamer. Yeah, see, that's very possible. Because she was like, I'll wait in the car. You go in and make sure we're really, really welcome. Because she didn't know if they were just invited because they were there and if it was like a politeness kind of thing. And I get that. Because some people are like that. Okay, good, Jelly Bean. Then I won't be alone. You're all still here, and I've been screaming for hours now. So that's just, I know it's not like politically correct, I guess. I don't know what's the term. What would be the term? It's like not appropriate. Like if I was in the courtroom, I would not be screaming. I realize that's not how you do things, but I just, I don't know. It's just the way I do it. Okay. Well, let me run, guys. I will be back. If I'm not back by 2, we will start at the beginning and catch up during breaks and such. And it looks like we might be here again tomorrow. So, and we're starting on April 1st, at least with jury selection. And a screaming goat. Yay! Okay, I told Travis about you typing the scream, the ghost screaming. He thought it was hilarious too. I can't remember if I told him I sent you one or not, though. Yeah, exactly. I keep wanting a case to end up in Gainesville or Ocala so I can go, but I wouldn't have near as much fun if I was in the courtroom. There was a case in Ocala, but I didn't find out about it until it already started, so I just watched it with on Recovery Addicts channel. We did her back before all you guys started watching, because I didn't have as many subscribers back then. It was, what was that woman's name? Her last name was Lawrence. I don't remember her first one. Was it Kathy? She was in Ocala. She killed her neighbor because her kids. Oh, good luck. My nerve block for my back worked. It worked great. So good luck. Bye, Terry. I forgot what I was going to say. Anyway, so if I'm not back by 2, we're not going to miss anything. So I'm going to go run errands real quick and be right back. So take care. Have a nice lunch, guys. See ya. Oh, wait. I have to end the stream first. I pushed the wrong button.